Division bench for pronouncement of judgment. Item 1.
The appeal is dismissed.
Supplementary item 54 for delivery of order.
The impugnator is set aside. The petition being Ms. J case number 184 of 2022 stands restored to file for a fresh decision. Both parties are directed to appear before the trial court on 2/2/2024 without waiting for any notice for appearance and seek further instructions from the said learned court.
I beg to mention item number 55 of the supplementary list.
Okay. On the prayer made by counsel for the petition, matter stands adjourned today. The staff is in due vacation.
Can the item be listed on 19th of this month?
Nineteenth will be immediately after that. Make it 22nd. 22nd.
At PP of that. Let me see if we can just reopening.
Pardon me.
Listing.
Listing, give it to the court master. All prayers for listing, give it to the court masters.
The question from the other side also will take to mention item number 51.
51.
Madam, may kindly be taken up after 2 weeks, madam. We need to obtain certain instructions.
This transfer, you have taken consent of the other side?
I'm for the petition.
Okay. Both sides are represented on the prayer made by counsel for the respondent. Matter stands adjourned today. Interim order stands. Interim order? Yes or no? No. List after saying, list after 2 weeks. Okay.
Problem. Consider the other side. I beg to mention item number 29 and 30 of today's list. Can be listed after petition. Some personal difficulty to take.
29, 30. You are for?
I'm for number 2.
Okay.
Lordship, I am appearing for respondent number 1, Lordship. Lordship, may kindly fix a date, Lordship.
Both sides are duly represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List on. After vacation, give a date.
Lordship, 15th of February.
15th of February.
Yes, sir.
15th is a hearing day. No.
7.
Make it 16th.
7.
16th. 7th.
7th.
Okay, 7 February. Okay.
November.
Highly open.
Wait, please. Back to mention, item number 12. Matter can be taken after vacation.
Okay, let's start the vacation as paid for by land counsel for the petitioner.
Lordship, I beg to mention item number 26 and 27, Lordship. It has been wrongly listed in orders, Lordship. It should have come for hearing, Lordship.
26, 27.
Lordship, any date may be fixed for hearing, Lordship.
Okay. Uh, you informed the other side? Okay. Okay, both sides are represented. It is submitted at the bar that the matter is ready for hearing. And so this matters for hearing in the month of February 2024. I'm not fixing dates to 2004 matter. It will come in priority. This will come in what you call top of the list items.
Apply.
I beg to mention item number 3, Lordship.
3. Okay. List after ensuing the vacation is paid for by counsel for the petitioner.
Is your lordship, I beg with the consent from the other side, I beg to mention item 22. 22.
Okay. You are for petitioner
Yes, and city respondent.
or respondent. Okay. Consent of the other side, then counsel for the respondent pays for adjournment. Prayer is allowed. List on. Give a date, fixed date after view.
After the.
You can make it 22nd, 19.
After 20.
After 20.
Much obliged.
Consent of the other side, mention item 33, daily was this. This matter, the original appellant had expired and I filed in IA for substitution. That apparently is not tagged. So, in absence of that,
The counsel for the appellant submits that the appellant has expired and he has filed an interlocutory application for substitution, which is not on record. List after issuing application along with the substitution application.
Top of the list, item 1.
Yes.
only point made out. Question at the time of whether the barred by whether the it is barred by you want some substantive question at the time of mission level. One substantive question level. One is 17.
1/11/17.
7.
Whether it should be title sheet number 2507 filed by Mr. Sharma relating to 14 lessons of land is marked by provisions of section 11 of the CPC. The judicata, as the same has already been adjudicated upon the earlier should be title sheet number 206 by District Judge Morigaon between the same party and same. Hello, there is a earlier suit, there was an earlier suit. That was, my lord, held by us for installation of particular cell below. Confirmation of possession.
You are the defendant.
In present is dependent. Earlier we are playing.
In the previous suit.
Yes. There are three brothers. One brother sold entire property. We said that's in the degree in the trial court, but appellate court held that this safety is valid for 14 lessons of that because each got a 14 lesson for its brother. So in the appellate court held that the 14 lesson for the 14 lesson is valid. On the hill embedded to the 14 lesson eastern part of the entire treadmill. And that first second was my never come to second appeal. So it is subsequently they realized that during the pendency of the issue, we dismissed from this 14 lessons of land. So he again fell suit for declaration of right attention and we go very position. That suit was negated. And in first appeal also from the title suit, the title disagreement. Now we can only small point whether the judicata.
But the agreement will not apply. If that is the case, if there is an allegation of disposition, then perhaps
Decree regarding 14 lessons, that degree middle passed by the appellate court earlier. So he should have filed the execution of decree middle regarding 14 lessons, not by a separate suit. Because same line again declared that he will be entitled to 14 lessons land middle. That is my technical point. Other argument it is clear that three brothers, two brothers 14 lesson, and brother 14 lesson, which was decreed in earlier title. In our suit middle, that is decreed.
so he gets the benefit not by virtue of what you call there are two kinds of saline. One is a saline, one is a dextrose. So he will get by way of a dextrose, not by way of a saline.
There is a delay of 5 years, 8 months for substitution. But luckily, this court allowed me for our earlier set of for substitution melody time 5 years, 8 months. That is why it is bound there. So it is a limited point melody. Whether the both is judgment regarding the it is not a judicata melody. That is only point.
No, but Mr. Chaudhary, that is the question. In the second present suit, insofar as the decree of declaration is concerned, that would not be there because you already have a decree, but it can be this what you call recovery of possession. Recovery of possession will be there.
My lord, in the earlier suit as well, the question was that a sale deed was executed by one of the brothers. One of the brothers being the one of the brothers of the present appellants. A sale deed was executed in my favor in respect of 1 kata 9 acres of land. The only finding which was reversed during the appellate stage of the earlier suit was that in the suit was decreed in favor of the appellants and stated that the sale deed is a nullity. However, in the appellate stage, it was modified to some extent and partly allowed, stating that the sale deed is only valid for 14 lessons of the portion of land. That was the only
14 acres towards the eastern side, that is your land. Present suit land is same. So declaration is there.
Declaration is there.
You can't get a repetitive declaration.
That
But the second part of the order that you are entitled to possession, that can be in your favor.
that can be very well.
But dispose of that. But Mr. P.S. Dekalanet, Senior Counsel. Assisted by Mr. Bhagwati, Learned Counsel for the appellants. And Mr. N. Chaudhary, Learned Counsel for the respondents. You are only appearing for appellant number 2.
No. Serial number my lord, there are 1 and 2, one right, my lord. So substitution. Substitution is there, my lord.
No, substitution is there, but here it is recorded. You are appearing only for respondent number 2. That's why appellant number 2. That's why I'm asking. Both, okay, for the appellants.
Nobody else substitute.
No, I don't, there's an endorsement made here that you are appearing for respondent number 1, sorry, appellant number 1, 2. That's why I'm asking. For the appellants. Next one. Assailing the concurrent finding, the present appeal under section 100 CPC is directed against the judgment and decree dated 12/11/2009, passed by the learned civil judge Morigaon in TA 14 of 2009, thereby dismissing the appeal and affirming the judgment and decree dated 16/9/2005, passed by the learned civil judge within bracket senior division bracket close Morigaon, or thereby decreeing the suit on contest. First of the appellant is the defendant. Oh, that suit number is not given in TS number. No,
2007.
25 of 2007. The appellant is the appellants are the plaintiff in the
My lord, the earlier suit of the present.
no present suit.
Present suit, my lord, 25 of 2007.
20 so it may mention that the appellant number 1 has been substituted by order dated 38/2017, passed in connected IAC 1724 of 2017. It may also be mentioned that the names of respondent numbers 3 to 9 11 and 16 have been struck off by order dated 19/2016. And therefore only the principal respondent number 1 and the pro forma respondent numbers 2, 10, and 12 to 15 remain as remain respondent parties in the suit in this appeal. Next paragraph. This appeal was admitted for hearing on the following substantial question of law. 11117. Order sheet page 18. You responded? Well, earlier in point of time, the appellants as plaintiffs had instituted TS number 10 of 2003 against Srimati Gita Kalita and Sri Tukeshwar Tukheswar Sharma SAR within bracket principal respondent hearing. As well as against Khargeswar Kalita, KHARGESWAR Kalita, and others within bracket pro forma respondents herein. Seeking declaration of right, title, and interest, confirmation of position, permanent injunction, and cancellation of sale deed number 185 of 2003. First off. The set suit was decreed on contest by judgment and decree dated 16/9/2005, passed by the Honorable Civil Judge within bracket Senior Division. It was Morigaon. The where is the appellate judgment?
Yes, you, which is the judgment?
Earlier appellate judgment.
Earlier judgment by Dr.
Exhibit 2, my lord.
No, it's not annexed here.
Yes, Alex Miller. For judgment, probably judgment is not the decree is that. Decree, the title bill number 2.
Page-
Page number 33.
83, yes. So appeal being preferred by the defendants therein by the defendants in TS 10 of 2003, which was registered as Title Appeal number 2 of 2006, the learned District Judge Morigaon partly allowed the appeal, and the decree passed by the learned trial court was modified by granting the following reliefs. 1 and 2, page 36. It is submitted at the bar that the said appellate decree had attained, that's appellate decree dated 16/9/2005, passed in TA, passed by the learned District Judge Morigaon in TA 2 of 2006, had attained finality. Next paragraph. The plaint of TS, next paragraph, in the plaint of TS number 25 of 2007, which was filed by the respondent number 1 herein, the principal respondent number 1 herein, it was claimed that he was dispossessed from the suit land falling in his share in respect of 14 acres of land. No, here it says 1 kata 9 lechas, which is right. Sale deed is valid for 14 lechas.
14 lesser, total land may not 1 kotha 9 lakh plus 14 lesser. Entire land should be. So 1 kotha 9 lesser is our land. And eastern side 14 lesser. Beyond 1 kotha 9 lesser.
No, come to page 47. Paragraph 4. During pendency of so and so, defendant number 1 and 2 disposes the plaintiff from complete 1 kata 9 lechas land. Which is right?
No, right, Milo. Because these are the only 14 lesser.
I don't know, but that's what I'm asking you.
Entitled to only 14 lessons, my lord. However,
But-
reading was made that from the entire land, which was mentioned in the earlier article.
It was projected that, don't write 14 lechas. It was projected that the principal respondent herein was dispossessed from 1 kata 9 lechas of land. Although in connection with decree passed in TA 2 of 2006, the share of the principal respondent was modified to the extent of 14 lechas of land. Covered by sale deed number 185 of 2003. Accordingly, the principal respondent number 1 had filed TS number 25 of 2007 with the following prayers. Page 48. A to F. Stop. The appellants herein contested the suit by filing written statement and amongst others took a plea that in the earlier suit, which is titled suit number 10 of 2003, comma, right of the principal respondent was affirmed only with regard to 14 leases of land. And accordingly, the sale deed was held to be valid only in respect of 14 leases of land. Did you take the plea of res judicata, Mr. Deka? Yes, and you can claim that the rights of the parties have already been adjudicated with the decision thereon. And accordingly, the suit was barred by section 11 of the CPC. Full stop. Yes, I have seen that. The learned Monsieur number 1, Morigaon, by judgment and decree dated 31/3/2009, decreed the suit full stop. It may mention that the learned trial court had framed the following issues for trial. Page 64, 1 to 6. Full stop. In respect of issue numbers 1, issue numbers 2 and 3, that is Roman 2, 3. Huh? 3. Now the court the learned trial court held that the issue in the former suit was regarding validity of the sale deed and right title interest of the appellant over the suit dag. And that the learned district judge had held that the sale deed number 185 of 2003 was valid only for 40 acres of land. And thus the right title interest of the appellant was declared over the remaining part of the land. First, however, on the ground that the right title over the 14 acres of land and issue of caste position was not declared in the earlier proceedings, it was held that the decision rendered in title appeal number 2 of 2006 will not be a res judicata in the present suit, and accordingly the suit was held to be maintainable. First up, issue number 1 regarding cause of action was declared in favor of the respondent plaintiff in respect of issue number 4, it was reaffirmed that the respondent, principal respondent herein had right title and interest over 14 acres of land within the schedule and falls within the aforesaid boundary, within the boundary of the said schedule. In respect of issue number 5, it was held that the respondent, principal respondent was entitled for a degree of khas position in respect of 14 acres of land falling in the eastern portion of the scheduled land as stated in the sale deed. Full stop. Accordingly, in respect of issue number 6, it was held that the respondent, principal respondent, was entitled to a decree for khas position and accordingly the suit was decreed by declaring that the respondent had right title and interest over 14 acres of land which falls in the eastern side of the schedule by the sale deed number 185 of 2003. And the applicants were directed to give vacant position of the said land to the respondent immediately. Next paragraph. The applicants preferred an appeal, which was registered as title appeal number 14 of 2009. The learned first appellate court I, the learned civil judge Morigaon, by judgment and by appellate judgment and decree dated 12/11/2009, dismissed the appeal by affirming the judgment and decree passed by the learned trial court. Next paragraph. The learned senior counsel for the appellants had submitted that that a declaratory decree in respect of the 14 discharge share of the principal respondent has already been decreed in the previous suit. And therefore, there is a duplicacy of same decree with regard to in the second suit, which was filed subsequently in point of time. And accordingly, they submitted that the appeal the subsequent proceeding was could not have been allowed to proceed as the suit was barred by res judicata, by principles of res judicata. And accordingly, he has made his submissions in support of the substantial question of law formulated by order dated 1/11/2017. That's or contra comma, the learned counsel for the respondent has submitted that. The, the principal respondent was compelled to file this subsequent suit as they were dispossessed from the suit land. But then, Mr. Chaudhary, please tell me, I've seen somewhere that you were dispossessed during the pendency of the earlier suit.
That is mentioned, my lord, in paragraph number 4 of the plaint. Thereafter, in the subsequent paragraph, paragraph number 5, it is also mentioned that after I obtained a decree of validity of the said deed, I had urged them for possession, but then again my possession was disturbed. Therefore, that is in paragraph 5 of the plaint.
No, but then again, you see, while I'm dictating a question as it will arise, you were the defendant in the previous suit.
Previous, my lord.
In the previous suit, you're right with regard to the 14 acres of land was affirmed. But since there was no counterclaim, the issue of giving you an order for possession will never arise. Therefore, is it not that your case is, it will be barred under the principles of explanation 4 to section 11?
That, my lord, again, if that is the case, I would humbly submit that the matter was not directly and substantially in issue, but the matter was collaterally and incidentally in nature therein. They had claimed for possession, the appellants herein had claimed for their possession and their right title herein.
No, but you could have taken that plea since you have foregone that. That pair in the previous suit, with regard to you were dispossessed during the pendency of that suit,
That's it, my lord. Thereafter, it is.
and you
stated-
allowed that judgment to come on board. It's not that by taking leave of the court, you have filed a suit for recovery of possession. So ideally, there should have been a counterclaim
There should have been
for them. But then you see explanation 11,
explanation.
explanation 4 to section 11, that will make it bad the adjudicator. Can you come out of that? Be prepared with that. We'll take it up at 2 o'clock. On that explanation 4, section 11. In the meantime, you can do some research. Any matter which might and ought to have been made a ground of defense or attack in a formal suit shall be deemed to have been a matter directly and substantially in issue in such a suit.
Is there, my lord, constructive res judicata.
Be prepared with that at 2 o'clock. Take it up. If you want the LCR, you can take it. LCR लगाओगे दीदी को.
Item 2, top of the list.
But in this matter, both parties claim whether the other side has enforced their land.
Pardon me?
Both parties claim that other side has enforced their land.
Okay.
But here, the plaintiff, he has taken a land measuring 2,000 square feet on lease from the municipality. If a lawsuit see, my lord, Then who visit them, exhibit exhibit 1 and 2. And there, my lord, land has been sold as 50 feet into 40 feet.
Just a moment. You are the plaintiff or the defendant?
Dependent counter.
Defendant, counterclaimant. चलिए एक मिनट में फिर आ जाइए। तो कर लीजिएगा इसको सुनाओ। Yes.
The lordship see the schedule to the plain, which is at page 7.
Yes.
No, my lord. The schedule says, my lord, 50 feet, all that land, parcel land measuring 50 feet in 42,000 square feet. Which, my lord, they have taken on lease from municipal, Dibrugarh municipality.
Yes.
Boundary has been shown, my lord, you can also see north municipal pitch road, south land of M Rao, you know,
Yes.
east M South, west Pilpar passage. Out of the aforesaid land, plaintiff is now possessing only 33 feet land on the eastern side and 40 feet on the western side and 50 feet on the northern and southern side. Now, this is the plaintiff allegation of schedule B.
Yes.
Schedule B, my lord, all the plot of land in possession of different land measuring 5 feet into 30 feet. being Mr. Sahib not the plaintiff situated on Gabru Patar ward number 18, that is so and so, so and so. North, land in person of division. Here they have said that north and Mumbai. South is Pakka boundary.
Yes.
Now, well, the plaintiff himself, my lord, admitted that the land is not a square land. Repeat evidence. And that is how, my lord. And in fact, my lord, there was reaction for maybe some land by sublocation. Two reports are there. I am, my lord, just substitute question of law, my lord, exhibit 8 will be the part. Exhibit 8, my lord, we can also consider that what the trial court has referred to these two exhibits 7 and 8 only, my lord. It has not considered it. And appellate court has not even referred to it. Yes.
Just a moment, Mr. Saikia. You see, by way of a mandatory injunction, order for removal of construction can be issued. Unless there is a declaration, what do you call, by a mandatory injunction, order of demolition, you'll have to satisfy is that it can be passed.
So far as the land in possession, my lord, it is not disputed.
No, I'll tell you, let him complete.
Yes.
This is the question you'll have to
At the-
respond.
At the beginning, it says the issue is with regard to the, my lord, encroachment of the land. But my.
No, whatever
my
it be,
suit is only
we will, no, let Mr. Savala complete, but this is something which you'll have to answer.
My lord, if you also see the judgment of the trial court, my lord, exhibit the issue number 3. Page 29.
Yes. Yes.
Whether defendant has constructed a house, my lord, taking 5 feet, then that's it. Now, whether defendant constructed his house in the, against the rule of renewable development order of leaving 5 feet of the land boundary wall. 51 plaintiff reiterated his claim, evidence and it's that a defendant enclosed 7 feet of the land on the southern boundary, he applied to the Digua Municipal Authority on 5/3/2099, seeking permission to raise a Pakka boundary wall on the side of the leaving 7 feet of the enclosed land. Exhibit 5 in the receipt of the Digua Municipality in respect of raising Pakka wall. Exhibit 6 the sketch map of the boundary wall. Exhibit 6 the signature on so-and-so defendant possessing land outside the boundary wall of the suit land has extended his house past that kacha wall and then roof most past the projected on the plaintiff's boundary wall by about 2 feet. of the land described in the Schedule A, and then tell eliminated the land. As such, defendant violated the provision of municipal and development authority bylaws, which requires any construction by leaving 5 feet on both sides and 10 feet from the side so and so other position. Circle officer Dibrugarh, Eastern Circle Dibrugarh, on the petition of the defendant demarcated the lands of both sides and submitted 2 reports. So and so exhibit 7 and 8 respectively. He has referred to these exhibit 7 and 8, but has not considered. High Court has not considered what is there in the. During consultation, people were one denied the suggestion that on the southern side of the boundary wall of the road, he built the house. He admitted that dispute is just by the southern boundary land. Now, if you also see, in the plain manner, he has said, I am on the northern side. And now he said, in the southern side. Don't know what it is. He stated that in 1999 he took permission to construct boundary wall, and from exhibit 6, it's seen that this boundary of the house measuring 10.36 meter, northern boundary 12.2 meter. Admitted that he had not constructed boundary wall on the east and west side. He denied the suggestion that the height of the boundary wall on the southern side is 8 feet. He denied the suggestion constructed the wall of the house on the boundary of the northern side and tin roof of the said house rests on the boundary wall. He denied the suggestion that said boundary wall contains windows and doors. He denied the suggestion that can cross 2 feet into 60 feet land of the defendants on the southern side. He denied the suggestion that without keeping the boundary of the southern side, he constructed the house. He admitted that since the days of taking land, only defendants have been residing and possessing the land. Well, this is very important, my lord. When he
Mr. Sahil, I have not been able to follow your that north and south. Please come again.
north and south, my lord, here what happened, my lord? Here he said the south, my lord,
Yes.
south of his land. On the south of his land, he had constructed boundary wall.
In the pleadings, you have shown encroached land of 5 feet 30 inches in the north.
In the north. He said in the north.
Here, where is
Here
that
he
south?
said, my lord, yes,
Oh, it's a southern boundary. He admitted that dispute is with regard to the southern boundary of his land.
my lord.
Yes.
No. The third paragraph, we do not see distinguish persons from either side from the plaintiff has raised the boundary wall on the southern side below the roof of the existing house of the defendant. He denied search of the plaintiff as enclosed to fit 60 defendant. During prosecution, the plaintiff had not taken any permission for raising the boundary wall.
Just a minute. Mr. Sayona, just a minute. Yes.
EW1 data that the defendants claimed in the evidence of the during prosecution, he stated that they are measuring so and so the plaintiff and is defendant's land is so and so and plaintiff's land is so and so. He denied the size of the plaintiff as well as the defendant's land. During DW2 in his post examination, reported about 5 years back, defendant number 1 and 2 had shifted to Bihar and have been residing in Dibrugarh presently. He stated that by knowledge, defendant number 2 has stated in the stated that municipality 3 feet land is in his patta. He stated that defendants have their house over the land since about 50 years. Another council defendant submitted that no documents citing the permission of the construction boundary wall was filed. Plaintiff Larva Council Fund submitted that as per section 13 of the Counter Content Planning Act, within 1 month of application is not rejected, then presumed to be allowed. On consent, said submitted found that plaintiff has given 5, which is receipt of the Development Authority in respect of raising the Pakka boundary wall, and exhibit 6 is a sketch map showing boundary wall. Nothing in the record suggests that permission applied was not granted. Review court have deposed that plaintiff has not taken any permission raising boundary wall, but he has not referred to any official letter or document. Agreed file reflects the receipt, the application, and there is no piece of paper to suggest that application was rejected. Hence, section 13 code of the application not rejected within 1 month of filing it is resumed to permission is granted. Hence, this is not from the evidence on record people to prosecution that the house is along the boundary wall has a deed roof, and since childhood have been defendants have been residing on their land. He denied the size on that plaintiff have raised the house below the roof of the defendant. He had stated the boundary wall was not raised below the roof of the defendant. Further evidence of the record, the evidence that defendants were residing on their land before plaintiff took the land under his possession. This is very important, madam. Moreover, from the evidence of record, he found that the defendants could not rebut the plaintiff's evidence, and they extended their house that is violated the rule of Development Authority, not leaving 5 feet of the land from boundary wall. Considering above, it can be inferred defendants had raised such a house room, not cast, projected over the southern boundary wall, raised to the land, and thereby causing rainwater fall immediate sources. Take my lord, with your lordships, take up the exit 8, my lord.
Just.
So as per their leases, it was more like 15 into 40. But that is not correct, my lord, because that even plaintiff has admitted that that is not expired.
Just a moment. feet 8, you said.
Plenty document.
Exhibit 8, yes.
ফলত এটি সাবজেক্টিভ যুগ প্রকরণ হল মহোদয় উপরোক্ত বিষয়ের প্রসঙ্গত মাটি সহকারে জনাও যে যোৱা 27/7/2003 তারিখে এই কার্যালয়ের সংশ্লিষ্ট লাট মন্ডল দ্বারা কেরাম বাজার 27তম দাবি অর্থাৎ 524 নম্বর ডাগর টুকর পৌরসভার মাটি আর ডাবল পথার উপরিও 81 নম্বর ম্যাদি অর্থাৎ 187 নম্বর ডাগর মাটির সীমা নির্ধারণ শ্রী প্রসাদ দাস যাদব আর নন্দেশ্বর জাতি আর অন্যান্য সকল সন্দর্ভত করা হয় শ্যামবাজারের উপরোক্ত 534 নম্বর ডাগর শ্রী নাগেশ্বর যাদবের মাটি পূব ফালে 35 ফুট তারে 32 ফুট 6 ইঞ্চি মাটি যাদবৰ দখলত আছে পশ্চিম ফালৰ প্ৰায় 42 ফুট তাৰে দখলত 24 ফুট 7 ইঞ্চি আছে উত্তৰ ফালৰ দক্ষিণ ফালে 53 ফুট 7 ইঞ্চি 534 নম্বৰ ডাগৰ উপৰি অংশ 35 ফুট 54 আৰু 52 ফুট 42 টোটেল 1995.43 ফুট 13.32 কোনো পক্ষই মাটি বেদখল কৰা নাই
Please give that again, that measurement. Please give it again.
পূব ফালৰ 35 ফুট তাৰে
No, this is whose position? Plaintiff's position.
32 ফুট মাটি যাদবৰ দখলত
Just a moment. Thirty-five foot.
35 ফুট তাৰে 32 ফুট 6 ইঞ্চি মাটি যাদবৰ দখলত আছে পশ্চিম ফালৰ
Just a moment. Yes, invest.
পশ্চিম ফালৰ ৱেষ্ট সীমাত প্ৰায় 42 ফুট তাৰে যাদবৰ দখলত আছে 40 ফুট 7 ইঞ্চি
Yes.
উত্তর ফালার যুগ আর দক্ষিণ ফালার যুগ 53 ফুট 7 ইঞ্চি 534 নম্বর উল্লেখিত অঙ্কর যুগ হয় average here taken 36.54 into 52.42. Total is 1995.43 per feet. That is 13.30.
$36.55.
0.5 into 5.
52.42.
So total it comes to 1995.4 per foot. He has taken land measuring 2,000 square feet from the board municipality.
Yes.
That one statement has been given, now let's say.
Yes.
Defendant's land is diagram number 187.
This person who gave this report, Exhibit 8, was he examined?
No one.
No. Yes.
My lord, this is executed by the plaintiff. Executed by plaintiff, he has executed the signature of the exhibit 81 as circle officer.
Yes.
Look here, in view of the size of the land, as well as the allegation that defendant is violated. But we have raised a point, Malad, that Dibu municipality is a necessary party. The issue number 2 has been held, that is decided against us, Malad. Both of those. But the land which LTV is possessing, that is municipal plan. Is taken on lease. And side is shown as 50 into 40 feet in the lease deed. But actual size is different. And if you also see the appellate court judgment, my lord, he has not considered exhibit 8 at all.
Let's come to that.
Yes. Sir. If you also come to the page
This,
54, judgment,
in the trial court, how did it deal with this exhibit 8?
but he has not dealt with only the part that I have placed, my lord, in the page 29. Page 29, my lord, the issue number 3, after the last line. Circles are Dibuga responsible on petition of behind the demarcated lands of both the parties and submitted 2 reports, so exhibit 7 and 8 respectively. That's this one. Except that nothing wrong. While deciding issue number 4, my lord, whether counterclaim is reasonable, my lord, he has not considered these things. Now, you have also go to appellate court judgment, my lord. Which starts at 44, but I am coming to the main point. At page 51.
Just page 51.
Last 2 paragraphs. That's number 3.
Yes.
Darren Muchino recite issue number 3 in affirmative and in favor of plaintiff. From the plaint and the evidence of 1, it is revealed that defendant had encroached 7 feet of his land on the southern boundary. But the plaint says northern. But in evidence, he has said southern. That is correct. It also reveals that plaintiff has applied to the development authority on so and so permission. But this is, I am not giving much. Hello? Permission for Paka boundary wall on the southern and leaving 7 feet of the land and so. It is reveals that 1799 defendant possessing the land outside the boundary wall, the Suitland, extended their house and cut a wall. And Melody, see that which mentioned southern boundary. And a roof almost cast and projected the plaintiff's boundary wall by about 2 feet inside and described in the schedule A. And rainwater fall and inundated the. Defendants have avoided in the evidence that the plaintiff has encroached the land of the defendant. PW1 has denied the assertion that the defendant had that on southern side, upon boundary of the road, he built his house. And PW1 also denied the assertion that he constructed the wall of his house on the boundary of the southern side and the thin roof of the said house rest on the boundary wall. PW1 has further denied the assertion that he has encroached 2 feet and 2 feet into 60 feet land of defendant on the southern side. And he, without keeping the boundary on the southern side, constructed the house. PW2 in his constitution stated that the wall on the southern side of the plaintiff house and boundary wall are separate. PW2 denied the assertion that plaintiff has raised his house below the roof of the defendants and plaintiff has encroached 2 feet into 60 feet of the defendant's land. PW3 and 4 also denied the assertion put by the plaintiff with respect to encroachment of the defendant's land by the plaintiff. The counsel for the defendant, plaintiff responded, submitted in the argument that as per provision of, well, this is, I'm not pressing too much. Now, from the oral and documentary evidence, it is clear that defendants have encroached the land of the plaintiff and raised their structure house in the matter that is roof is dust and projected over the southern boundary wall raised upon the suit land and thereby causing rainwater to pool and inundated the property of the plaintiff. In view of the discussion made above, the court worked that municipal to write its suggestion. My lord, the court has, what the court said that is southern boundary.
It's a way of national integration. There is no north and south divide in the country.
And the circumstantial report says, my lord, there is no enforcement by the side.
That's all. Yes.
First of all, my lord, my pleaded case is that, my lord, this my lord, land measuring 40 feet by 50 feet has been leased out to me. And the defendant has, my lord, encroached about 5 feet and odd in length of the my lord, plaintiff. I have constructed the house with the permission of the my lord, board, admitted. I have applied for the my lord, permission for construction of the boundary wall. Within a month, it was not given. I have constructed, so it is a deemed permission. The existence of the southern, my lord, the boundary wall is admitted fact. My contention is that whatever he has encroached, then I made the southern boundary with the permission that I have already applied for. To that extent, my lord, it is an admittable. It is not a case that I have saying in the plain that it is northern side. This southern side, I have mentioned in the plain southern. Emphasis has been made that I have in the plain, I have said it is on the northern side,
That's what the pleading is.
southern,
Yes. No,
Yes.
northern.
southern. That's not the plain is at page. Four. Paragraph 3. That on measurement, it was found that the defendant encroached upon 7 feet of suitland on the southeastern boundary and created various problems. That on 1799, the defendant who is possessing some land outside the southern boundary of the suitland extended his house towards the southern boundary of the land of the plaintiff described in Schedule A. But my contention is that after construction of the boundary wall, he has constructed his house without leaving the space as required under the building by zoning regulation of the Dibrugarh municipality. Just attached to the boundary wall, and the roof tin that he has fixed it encroached to my, the boundary wall, and thereby all the rainwater are falling, in my boundary. That is my case. So therefore, I said that without permission, he has constructed this, so this needs to be, removed. And that was, for the purpose of mandatory injunction as well as the perpetual injunction. The court, while deciding the issue number 3, it is found that the construction made by him is without any permission. So therefore, the projection of the tin roof are directed to be removed. That much is the case. So far as he is concerned, he has filed written statement as well as counter claim, alleging that I have encroached upon his land. So thereby, he wanted a declaration and also, eviction, of the plaintiff from the land.
I don't know, you see, page 7 is very clear. Not land in possession of the defendant. Page 7, schedule B, north is land in possession of the defendant.
Defendant. But not, he might be having other plot on the northern side, but south you will achieve pakka boundary wall of the plaintiff. And this was never an issue, man. This was never an issue, my lord. And now what is the substantial question of law your lordship has seen, my lord, by the order dated 23/12/2009. Whether, my lord, the non-consideration of the size, difference of, my lord, mentioning of the difference of the size in the exhibit 1 and exhibit 8. Materially, my lord, affected, my lord, whereby the decree needs to be reversed, whether it was a case, my lord. So far as his contract claim, it was not considered by the trial court. He did not prepare any appeal against that. So far as his claim is concerned, that is gone. Although from the report, it reveals I have not, he has not encroached upon, but the measurement you also will find in the cell is 20 into 50, 2000 square feet. And whereas in exhibit 8, it comes to 1915 square feet. And in the plate also, I have mentioned the size of the plate are not equal on all the sides. So whether at all I have substantial question of law, so far as deciding this issue. Suppose, it has been held, yes, its size is different. Whether his admission that existence of the southern boundary can be wiped off. And whether the finding of the court that he has constructed the house in violation of the municipal zoning regulation, that will go. It's a very simple case, madam. The boundary wall he has made his house. The wall contiguous to the boundary wall, and thereafter the roof tin was leaning towards my lane where all the waters were flowing. That is the only issue, madam. And both the courts categorical finding that there was no permission, construction is illegal. So therefore, he was directed to remove the encroachment, whatever he has made, by way of extending the tin roof. So far as possession of the boundary, the land, it was not in dispute. I did not claim in my suit that the encroach for a declaration that so much of land has been encroached by him. It belongs to me, so therefore he is liable to be evicted. It was his case rather, which by way of counter claim. And the fate of the counter claim, as I have already discussed. So my contention that this is not a substantial question of law at all, so far as this case is concerned. And second substantial question of law is regard to timing provision pursuant to section 13 of the Town and Country Planning Act 1959. Well, this is also not a substantial question of law because this has been, my lord, already decided by this court in catena of decisions, my lord. That if, my lord, within a period of, my lord, a month, of course, my lord, the perimeter provision in the, my lord, under the GMC Act, my lord, and the building bylaws. Perimeter, what say?
But that has been interpreted in the case of this Priyanka Estates, that there is nothing called deemed permission.
My lord,
And the division bench has said that the permission, even if not granted, the deemed permission also, that formal permission has to be issued.
my lord, there the issue, my lord, when it violates, if the everything, my lord, after the deeming permission, everything within the zoning regulation, in that case, my lord, it is permitted. If it is violated, that cannot be considered to be a, my lord, deeming provision.
No, that's not the decision in Priyanka Estates. In Priyanka Estates, it says that the deemed permission itself does not create a right to construct. That has to be,
I'm referring to, my lord, this Gulab Sharma case, my lord. And thereafter also
because that is, the Priyanka Estates is a division bench judgment.
this view also endorsed, my lord, in a division bench, my lord, in 2017. And so far as, my lord, the other way
Just
also,
a moment.
other way also, my lord,
Just a moment. Yes. Yes.
That's what I'm referring to this 1995 decision. Sorry, 1995 2 GLT 365. Paragraph
19,
95 3 GLT 365.
page.
365.
What is the name of the parties?
Sri Gulab Sharma. Last part of paragraph 7. There is no dispute with regard to this proposition of law, but in this case,
Nineteen 1995 3 GLT 365. Gulab is GULAB.
GOLAP.
G
OLAP.
G3 GLD. No, 2.
Is 2 GLT.
That's why. Yes, which paragraph?
The last part, discussions are there on the last part of paragraph 7.
Yes.
There is no dispute with regard to the proposition of law. The provision is quoted in paragraph 5.
Yes, yes. Yes.
Was also, my lord, endorsed, my lord, in a division bench judgment, my lord, 2017 1 GLT 389.
Okay.
My lord, paragraph 15.
I'll take a break and come back.
But 2017 also, my lord, this appears, my lord. Para 15. On the issue of deemed permission under section 13(4) of Town Planning Act, the legal presumption should be drawn only for a bona fide applicant who may be denied the timely response from the regulatory authorities on the building permission application. The objective of the legal consequences is to protect the genuine applicant from the procrastination of authorities and likely abuse of power by them. In such situation, the fictional permission envisaged by section 13(4) can benefit the bona fide applicants, but what is seen here is an unscrupulous builder who started vertical construction without permission and when so institution. So far as bona fide, I am a bona fide, there is no dispute about it, madam. So that permission is there, madam. Most even if it is taken that such a hold that this permission is not required. Now, whether this would be a substantial question of law, because that will confine to the southern boundary I have constructed, for which, my lord, his counter claim, though was there, my lord, it has been dismissed, no relief can be granted. He may have a, my lord, separate cause of action for filing a suit for demolition of my lord, building up on the southern that boundary wall. Now, the only relief in the entire suit, my lord, that the extended projection of its tin roof, which is coming to my land and all the waters are, my lord, falling and they have inundated my farm. That much relief, not any, my lord, land as such. And the court has held that his construction in issue number 3, that his construction is without permission. My humble submission, my lord, none of this, my lord, question that has been formulated are the substantial question of law so far as this case is concerned. The other objection is that, my lord, I did not make municipality a party. I have not, my lord, sought any, my lord, relief against the, my lord, municipality. I am a bona fide lessee of the municipality. I have all the right to protect my landlord's rights and, my lord, interest. It also stated my lord, that exhibit eight is not at all referred to in the my lord appellate judgment. The page 54, second paragraph. The case record reveals that exhibit 7 and exhibit 8 are the reports of Lakshmandal dated 5601 and 13/8/2003 in respect of Suitland. However, those reports even do not disclose about any encroachment of defendant's land by plaintiff. Is also considered by the trial court. It's 32.
I'm sorry, madam, that is kept. But this report does not reveal encroachment of defendant by the, of the plaintiff land.
I'm not on the, my lord,
Because it is already into about 2,000 square feet of land. Only.
I'm not
the
on
site
enforcement.
is-
Also, it's in my release that I have sub form. Page 34, my lord, on 32 also trial court referred. On consideration the evidence on record, it is found that PWs have denied the suggestion that plaintiff encroached defendant's land. On perusal of document exhibited, it is found that exhibit 7 and exhibit 8, the report of Lakshmandal dated 5/6/2001 and 13/8/2003 respectively does not disclose about any encroachment of defendant land by plaintiff.
Yes. Yes.
EW4, my lord, was the assistant executive engineer of Vigo municipality has stated that referred in page 54. The construction is made by the plaintiff at a distance of more than 5 feet from the boundary. The southern boundary, there is a 5 feet gap, then the construction being hosted.
Page 62,
Page 54.
54. Yes.
The case record revealed that exhibit 7 and 8 are the reports of Lat Mandal dated 561 and 13803 in respect of Sutlan. However, those reports even do not disclose about any encroachment of defendants led by plaintiff. PW4 being the assistant executive engineer of Dibrugarh municipality has stated in his cross-examination that construction is made by the plaintiff at a distance of more than 5 feet from the boundary. This was scrutinized this exhibit A7 and 8 in respect of his allegation that I have encroached the land. The report is also clear that there's no encroachment from either of the side. And this, the PW4 also said from the boundary wall, 5 feet gap is there. Thereafter, only his house is there. So this 5 feet. Now my relief is over the boundary wall, his tin roof have been projected in such a way already rainwater comes and thereby this 5 feet strip within my boundary, I am not been able to.
You're not interested in free water.
But nowadays, with this manuring, this chemical manure, I need some place also to grow my vegetables also, Very essential. And counter claim has been rejected. He did not prefer any appeal. He has any objection, my lord, with regard to the boundary, etc. This can be raised at the time of execution of. Priyanka case, my lord, I have just now gone through. It's a totally on different context.
Pardon me?
That Priyanka deals that case, mentioned. I've just gone through it's a different, my lord, altogether different. Because there's an illegal construction, my lord. They were given permission only up to the 4th floor and half portion of the 5th floor. Then, my lord, they have started construction. Demolition notice has been issued. It was appealed. Then again, my lord, the appellate authority or the my lord, authority in charge, my lord, asked him to observe certain conditions, undertaking, etc. Without doing that, he proceeded. So therefore, my lord, again, my lord, demolition notice was issued. They have opposed the right. So in that context, my lord, that deeming provision would definitely not come, my lord.
This one, Mr. Sahada.
Well, it's only sometimes something activity said that he positioning into about 2,000 square feet of that. He has taken. Only my lord, the size of the plot is not as per the deed, my lord. That is why I said, my lord, that size is not correct. And plaintiff himself admitted that yes, size of plot is not.
This, Mr. Saikia says that you are only aggrieved by the decree passed, not the counterclaim.
Exactly, my lord, it was jointly passed, that is why, my lord, we have prepared, my lord. In the appellate court has also considered.
That leave was never taken for counterclaim, there were no court fees or was taken on, it was not filed. So you see in that, the question was arise that if the construction is prohibited within that 5 feet area, so by way of injunction, you are asked to obey that mandate of law to have your construction within by excluding 5 feet area. So they are not asking to evict you from that land. They are merely saying that within that 5 feet area, prohibited area, your construction should not be there.
They said in their land, they have constructed. But as per exhibit 8, my lord, they are possessing 2,000 square feet land.
No.
Nobody does court.
No, what I understand from his submission is that the boundary wall stands as it is. He is not asking to evict you. What he is trying to say is that the construction within 5 feet of that boundary would be illegal.
That's my lord. You can also see, if you also see just a plain, my lord.
Didn't the there is mandatory injunction to demolish?
Yes,
The-
that also I.
But if it is illegal, the court can't say yes
Hello?
to that. The construction over that 5 feet area, which is which can't be made.
5 feet, where is the 5 feet, my lord? He is already possessing, my lord. He say, my lord, a week of, my lord, by demolition of the structure. That is not, my lord, boundary, my lord. Not within the boundary.
No, within the boundary, but within 5 feet of that boundary.
No, not that, my lord. That is the question, my lord. That is the question. He's already decided.
He's not asking your eviction.
Hello?
Mr. Saikia is saying he's not asking your
That is
eviction.
not, my lord.
No,
This is- my lord, actually, my lord, this is, if you also see, what he is asking. That is northern side, that schedule is also wrong, my lord. It will be all that plot of land in possession of the defendant, measuring 5 feet in 30 feet, being municipal site number so and so not known. The plaintiff situated in Abdul so and so, Dibuga town. Eviction, my lord, you see. It's eviction. Any mandatory, my lord, injunction, but it's eviction, my lord.
the plaint is at plaint is at page
Five, my lord, that's fair.
page 5.
You see another story.
Here you see the prayer is only mandatory injunction for removal of all construction and perpetual injunction restraining from making that construction within that be scheduled land. He's not asking for your eviction.
Well, that is, but demolition is the eviction, my lord. That is the question. Whether I have enforced the land,
No, no.
whether, my lord, if you also see, my lord, para 4, he said that by about 2 feet inside the land described as schedule, my lord.
No, let us say whether you see whether you have enclosed the land or not enclosed the land is will be immaterial. Since in the prayer in the plaint is not for your eviction, but merely it says from the boundary, no construction within that 5 feet area.
But that is also the your notice in my sleep para 4. What is there? But my lord is saying that
The defendant who is possessing some land outside the southern boundary of the suit land.
Yes. the house towards the southern boundary of the land of the plaintiff described in Schedule A in such a manner that Kacha wall of the defendant and his tin roof has been touched and projected as opposite Pakka boundary wall for the plaintiff by about 2 feet inside the land. That is what he said. Here 5 feet and 30 feet.
No, irrespective of what he has said, he is not asking for your eviction.
Well, my demolition itself is a eviction, my lord. He says that his boundary wall, my lord, inside a boundary wall. First thing, my lord, he must say that his land has been, I had constructed something on his land.
No, you forget his land.
Yes.
You stick to your boundary.
Yes.
Even at your boundary, if there is a 5 feet illegal construction, you would have a right to come to court and seek your,
That is not the allegation, my lord, here. That is not the allegation.
Allegation paragraph 4.
Paragraph 4, my lord, he says the 2 feet, my lord,
No, there's some more
Extend.
part there. It may be mentioned here that as per the municipal bylaw, the defendant is required to raise his construction on the land in his possession by leaving a minimum space of 5 feet Pakka boundary wall of the plaintiff and his house. But the defendant gave complete go by to the aforesaid bylaw of municipality and extended his kacha wall of the house touching the aforesaid boundary wall of the plaintiff. That the plaintiff requested the defendant several times to remove this kacha wall and the tin 5 feet away from the said Pakka wall of plaintiff on the southern side of the aforesaid boundary wall, but he is not yielding any attempt to pit corral with him. This 5 feet by so land fully described in Schedule B is the subject matter of the so.
So if you also see, my lord, the schedule.
you see, he says that the defendant is required to raise his construction of the land in his possession. So even if you have encroached, he says you are free to make that construction in your possession, but leave that 5 feet area.
No, my lord, not only that, my lord, you'll also see schedule A and B. His allegation is different, my lord. He is contradiction.
If the prayer is not there, what he wants is material.
Well, that you'll also see, my lord, that the eviction, my lord. If you'll also see schedule A, my lord, he said, my house is 50 feet and 40 feet. First part. Then out of the aforesaid land, the plaintiff is now possessing only 33 feet land on the eastern side, 40 feet on western side, and 50 feet on northern side.
Correct.
So he said that 7 feet on the eastern side is now less, madam. He is not in possession of 150 feet, 350 feet land.
Correct.
So that is why, my lord, that is the eviction, my lord. That entire, my lord, we have to say, my lord, what he said.
I don't know, it was difficult to accept that.
Because he is saying he is less in the less position. His evidence is also there.
No, he may have made so many statements, but the prayer is not there for your eviction, so it can't be presumed.
It also says, my lord, that he is possessing less land. That is why, my lord, he wanted.
No.
My lord, by way of mandatory injunction, he wanted to evict me, my lord.
But that's not the prayer. He's not asking for khas position. Delivery of khas position is not there. So even if there is an encroachment, let us assume that it is your land. It is not a encroached land. Let us assume for the time being that your
Encroachment, my lord. Allegation is encroachment.
no, it's okay. Let us test it in a different way.
Yes.
Let us take it that the land in your possession is a valid position. Correct.
First thing, your office can see schedule A, my lord, what is alleging.
No, you forget the allegation.
Yes.
Now let us come to an example. The land in your possession, let us say it is a valid position, lawful possession. Then also this 5 feet, you can't make a construction within that boundary of, within the boundary of your land.
That is why municipality has not been made a party, my lord, here. How much land is to be kept, my lord, nothing, nobody has kept it. Nobody has stopped it. 5 feet or whether side 5 feet is to be required.
But that is the provision of law. We can get.
No, my lord, that is not considered, my lord.
Hmm?
That has not been considered, my lord. 5 feet I have to keep, my lord.
But
And that is not the finding also, my lord. Not the finding also. Finding is otherwise.
Referring to 328.
It is clear, on page 31, issue number 3, last paragraph,
What is that provision? Assam Municipal Act?
13(4).
Hmm?
Not municipal act, there is a town and country plan, Assam town and country plan.
Assam Town and Country Planning Act. What is law so in color, light green. Mobile and law next. The episode next. Which provision?
13(4).
13(4). Where is the right for demolition under which provision?
My lord, here it is 30B, my lord. 30B.
মাতি দিব সেক্রেটারি মাতি দিব This, what is this kacha wall?
His house is kacha. His wall of the house is kacha. Kacha.
Mr. G. N. Savla, Senior Counsel, assisted by Ms. S. Todilan, Counsel for the appellant, appellants, as well as Mr. P. C. Saikal, and Senior Counsel, assisted by Mr. K. D. Saikal, Counsel for the respondent. Arguments concluded, judgment reserved. Item 4.
Lord, here it seems, my lord, I am the defendant. The plaintiff filed a suit, my lord. Can we see the prayer of the plaintiff, my lord? Along with the suit, injunction also filed, my lord.
You are the defendant.
I am the defendant. At page 16, kindly see.
Page
Page 16, 1 6.
6. Yes.
A decree declaring that plaintiffs are non-evictable occupancy tenant in respect of the suit land, for a degree confirmation of possession of the plaintiff over Schedule 3 land within Schedule 1 land, or degree of recovery of first possession of Schedule 2 land. This prayer is the basic prayer. Lord, actually, the suit land is a fishery land. It is the government land. Government-run fishery has been running over the suit land, and the government has sanctioned some amount, that is 25 lakhs, in favor of the defendant lessee for establishing a hatchery by the Assam Fishery Development Corporation. When the suit was filed, Assam Fishery Development Corporation was made party, but in injunction petition matter, they have not made party. I have invested government amount as well as my own fund and constructed a hatchery over Schedule 2 land, and I am running the hatchery. Now the trial court has held that, rejected the injunction petition on the ground that I am in possession. I am running the fishery, hatchery over 3 cutters on odd land in Schedule 2 land. So prima facie case, balance of convenience lost not lies in favor of the plaintiff, and the lower appellate court reversed the finding, although it was held that I am in possession.
Where is that? Where is that?
Regarding possession, at page 57.
This land belongs to the fishery, the state.
Our contention is state, and they are claiming that this land they have acquired occupancy right, occupancy tenancy right.
Where is the document to show that the AFDC has given you that?
Yes.
Where is that document?
That is admitted. That is admitted in the plaint also.
Where is that?
In the plaint,
Show from the plaint.
paragraph, page 14, para 5. Page 14, para 5. Got it. And kindly see page 56. Finding of the learned or appellate court, where the injunction has been granted. Page paragraph 34. It is an admitted fact that opposite party are in possession. Worship got it.
Page
56,
56, para
34. It is an admitted fact that opposite party are in possession of the portion of the whole suit land by constructing a hatchery, etc. And thus there is every scope of their part to future make such pakka structure, and thus there is a scope of change in the nature and feature of the suit land. The argument on of the learned senior advocate for the respondent opposite party that they have invested huge sum of money and government has also invested in the scheme, and thus in case the restriction put on them, hardship will be caused to them. I am of the considered opinion that public official dealing with the sanction of the scheme is to ensure proper implementation of the scheme and also to ensure the authenticity of the beneficiaries. Here, the concerned official failed to notice that the land was not in the name of the opposite party. Question does not arise because it initial stage. Suit was filed, injunction petition, the officials are not made party in the injunction petition. And later on, though settlement was made in the name of the sons of the opposite parties, thus the loss of inconvenience if caused to the government, it can be recovered from the hearing official, but a third party, general public.
but Mr. S.K. Ghosh, Land Counsel for the appellants, by filing this application under section 115 and 151 CPC read with Article 227 of the Constitution of India. One 115 you'll have to remove.
227.
So you strike it out. At the outset, the Learned Counsel for the petitioners has submitted that he may be permitted to strike out the provisions of section 115 and 151 CPC from the cause title, so that this application can be accepted as one under Article 227 of the Constitution of India. This prayer is allowed. The Learned Counsel for the petitioners shall strike out the provisions of section 115 and 151 CPC from the cause title. Next para, by this application under Article 227 of the Constitution of India, petitioners have assailed the oh, sorry, this was what you call this was a final judgment. Or then 115 will remain. No, don't write that. 115 read with so has assailed the judgment and order dated 23/11/2023 passed by the Learned Civil Judge Hailakandi in Miss Appeal number 14 of 2023, thereby allowing the appeal by reversing the order dated 31/5/2023 passed by the Learned Civil Judge within bracket Junior Division bracket close number 2 Hailakandi in Miss J case number 27 of 2022 arising out of TS 24 of 2022. Page 1 of the cell. Issue notice on this. Issue notice returnable in 4 weeks. Give a date after 5 weeks. returnable also. The petitioner shall take steps for service of notice on the respondent. The respondent is by registered post with AD. Postal receipt number, postal track report prior to the next date of listing. Next, heard the learned counsel for the petitioners on the prayer for interim relief. Stop. Next, the petitioners are the defendants in TS number 24 of 2022, which was filed by the respondents for declaration of tenancy rights over the suit land and confirmation of possession. Stop. The District Fishery Development Officer Hailakandi was arraigned as defendant number 3, and the state of Assam, represented by the district collector, Hailakandi, was arraigned as defendant number 4. Sorry, pro forma defendant number 3 and 4, respectively. Stop. It is noted that in paragraph 5 of the plaint, the respondents plaintiffs had admitted that when they visited the suit land on 7/2/2022, they saw a signboard of a government project of construction of Finfish Hatch, FISH, Finfish Hatch, HATCH, within bracket woman, under Pradhan Mantri Matsya, MATSYA, Matsya Sampada, SAMPADA Yojana, within bracket 2020-21, over the suit land in the name of the petitioner number 1. Stop. In connection with the prayer for ad interim injunction, the learned trial court had rejected the prayer for ad interim injunction. It was rejected on the ground that the petitioners were in possession of the suit land and that no irreparable loss would occur to the respondents. First of the learned First Appellate Court affirmed in paragraph 34 of the appellate order, accepted that it was an admitted fact that the petitioners here are in possession of a portion of the suit land by construction of hatcheries, etc. Yet the petitioners were restrained from changing the nature and feature of the suit. Schedule 2 land, 2 is Roman 2, and from disturbing the peaceful position of the respondents as plaintiffs over the suit Schedule 3 land till disposal of the suit. First off, it is Also observe that in the injunction application being BJ case number 27 of 2022, the government authorities who were defendant numbers 3 and 4 in this suit were not made parties. Full stop.
In the appeal also.
Similarly, in the if he's not a party, there will not be an appeal.
Appeal filed by them.
No, if they are not parties in the suit, they can't be parties in the appeal. So therefore, if the petitioners are in possession of land pursuant to a government project, the court is of the considered opinion that till the rights of the parties are decided, the petitioners would be entitled to carry on their activities under the government-sponsored project. In the event the fishery was allotted to them by the
Fishery Development.
Assam
Fishery Development Corporation.
Assam Fishery Development Corporation through the District Fishery Development Officer, within bracket, pro forma defendant number 3 in the suit. So far as Schedule Roman 2 land is concerned, next one, therefore, the operation of directions contained in paragraph 53 of the appellate judgment dated 23/11/2023, passed in Mace Appeal number 14 of 2023. Is state so far as directions in respect of injunction in respect of Schedule 2 land is concerned. However, without affecting the injunction granted in respect of Schedule 3 land, 3 is Roman 3. Stop. Next paragraph. It is further clarified that whatever constructions are made on Schedule 2 land shall be subject to outcome of the of title suit number 24 of 2022 or further orders of this court. List also as well. Continue at 2. Just ask Nihal Chaudhary to meet me in the chambers for a moment. I have to communicate something to him. Ask him to come at 2 o'clock because there's a meeting, I would be out at 2 o'clock.
me please. Lordships, perhaps in this case, during the pendency, during the earlier suit, during the pendency of the suit, there is a statement that the possession of the present respondent was interfered with, but it was in respect of 1 kata 9 letters, which was originally in respect of which the sale deed was executed. Thereafter, in that particular suit, the sale deed was declared as null and void. In that juncture, my lord, if I may submit that at that point of time, there was a break in my title. It was decided that the instrument of title which was conferred upon me was null and void. And at that point of time, the wife of late Sitaram Kolita, that is the defendant number 3 in my suit, was in possession. Thereafter, subsequently, when an appeal was filed, that very order was modified, and I then gained a new right in respect of 14 letters of land which was available to that particular brother. In order to agitate my right over that 14 letters, subsequent to being granted by that modified order, I approached the defendant numbers 1 and 2 here, and it is at that point when again my requests were turned over, and that is presented para 5 of the plaint in the new suit. And that gives, in my humble opinion, my lord, that gave rise to a new cause of action for which this suit is maintainable, at least with regards to the recovery of possession of that particular 14 letters of parcel of land.
The previous suit was by Mr. Dekha.
With the appellants.
And in this, in their case, they had sought for confirmation of possession.
They have sought for right title interest, confirmation of possession, and declared that my sale deed was an
Your sale deed is invalid. So now in the second suit, because you see the primary factor that they are in possession is already there in the previous plaint.
Is there in the brief. What I am trying to impress, my lord, is that this issue regarding my right title interest was not an issue which was directly and substantially an issue in the earlier suit. It was rather incidental and collateral in issue, and it was decided during in the appellate stage.
Please come to the plaint. The plaint is at page 44. Here you are saying that during the pendency of title suit 10 of 2003, defendant number 1 and 2 of the suit forcibly disposes the plaintiff from the complete 1 kata 9 letters of land.
Because, my lord, this was the parcel of land with regard to which the sale deed was executed.
But the disposition you see in, even in paragraph 5, 4 and 5 read together, would mean that your disposition was in the, during the pendency of the previous suit.
Yes, my lord, it was during the pendency of the.
So you see that, what you call, irrespective of the prayer of declaration, but the fact that the prayer of, for recovery of possession, as far as that prayer is concerned, you have to show us within the meaning of
My
our
lord, I'll just write it.
explanation 4.
My lord will take up from para number 11 at page number 5. May I read, my lord?
Just a moment. Para 11, yes.
The words collaterally or incidentally an issue have come up for interpretation in several common law jurisdictions in the context of the principle of res judicata. While the principle has been accepted, the matters collaterally or incidentally in issue are not ordinarily res judicata. It has, however, been accepted that there are exceptions to this rule. The English, American, Australian, and Indian courts and jurists have therefore proceeded to lay down certain tests to find out if even an earlier finding on such an issue can be res judicata in a later proceeding. There appears to be a common thread in the tests laid down in all these countries. We shall therefore refer to these developments. May I read the rest of the whole part? That was good.
Which para?
My lord, there are actually discusses about this.
Yes.
My lord comes to next page at para 17.
Yes.
American jurists and courts have also found difficulty, but they have tried to lay down some tests. It is considered in the corpus juris secundum that it sometimes is difficult to determine when particular issue determined is of sufficient dignity to be covered by the rule of estoppel. It is said that estoppel by judgment does not extend to any other matter which was only incidentally cognizable or which came collaterally in question, although it may have arisen in the case and have been directly passed on. But this rule does not, however, prevent a judgment from constituting an estoppel with reference to incidental matters necessarily adjudicated in determining the ultimate vital point. American jurisprudence who says under this rule, if the record of the former trial shows the judgment could not have been rendered without deciding the particular matter, it will be considered as having settled that matter as to all future actions between parties. Para 18. In India, Mullah has referred to similar tests. The learned author says a mere matter in respect of which relief is claimed in an earlier suit can be said to be generally a matter directly and substantially an issue, but it does not mean that if the matter is one in respect of which no relief is sought, it is not directly or substantially an issue. It may or may not be. It is possible that it was directly and substantially an issue, and it may also be possible that it was only collaterally or incidentally an issue, depending upon the facts of the case. The question arises as to what is the test for deciding into which category a case falls. One test is that if the issue was necessary to be decided for adjudicating on the principal issue and was decided, it would have to be treated as directly and substantially an issue. And if it is clear that the judgment in fact based upon the decision that it would be res judicata in a later case, one has to examine the plain written statement, the issues and the judgment to find out if the matter was directly and substantially an issue. This case aside. My lord, finally, it was held at paragraph number 20, last line, that the question arose whether the deceased and C were joint or separate, and the earlier finding was held not res judicata, inasmuch as the matter was not directly and substantially an issue in the earlier suit. What, my lord,
Yes.
what, my lord, I try to submit is that the issue of the right title in interest of the plaintiff in the present suit or the respondent presently was not a matter directly and substantially an issue in that suit. What was directly and substantially an issue was, my lord, the right title in interest of the defendant numbers 1 and 2, those are the plaintiffs here, those are the appellants here, their confirmation of possession, and whether the sale deed which was executed in my favor was void or not. That was particularly decided in the suit. As an incidental corollary to that, as a collateral finding, it was decided and modified in the appellate stage that I also have a right over the 14 letters of land, and that right for the first time was created post that appellate decision in the earlier suit. Therefore, my lord, what I pray before this court is that since that was the first time a right was created, it was only after that stage that I tried to agitate that right. And when I did so, it is very well mentioned in paragraph number 5 that when I did so, I was obstructed, and as such, this suit has been filed. Therefore, my lord, there was a distinct new cause of action for which this suit was filed. And the question of my right, which was decided subsequently during the appellate stage, was not something which was directly and substantially an issue as is the mandate of section 11 of the Code of Civil Procedure. And therefore, res judicata for this particular purpose of possession might not apply in this case.
You see, please come to the initial paragraphs, para 2 to 4 of the judgment you are citing. You see, there were 2 previous suits with regard to the properties at Ahmedabad Rosa. Rosa in Arabic would mean it's a shrine, tomb, or whatever. It's related to some religious structure. So the first part, para 2 and 3, deals with this Ahmedabad Rosa. And you see, in this in para 2, the last line, basically the plea of res judicata is confined to rosas of Broch and Surat. Correct? Para 2. Para 3 also you will find about 4 lines from above. In fact, the present proceedings, the Joint Commissioner and Assistant Judge and the High Court have all applied the ratio of 2 decisions relating to Ahmedabad Rosa on the question of res judicata in relation to Broch and Surat. Correct? So it is in this aspect that this, what do you call this, Supreme Court is viewing this matter. So it says that the right, insofar as it fructified for the Ahmedabad Rosa, with regard to the same persons, there in Surat and Broch, it could not have been applied because it's only an incidental issue. But here it is the same land. In the same land, you say that you have been dispossessed in the first suit. It's your case that that you are not in possession. So you see, it's not a case of staking a claim within the meaning of Article 65, saying that suit based on title. So because that adverse position was never claimed. So distinction between 64 and 65 is not really relevant here. Therefore, the only question is that when an issue of disposition could have been raised in the former suit, and if it is not raised, because there you are the plaintiff. Whether in the subsequent suit, notwithstanding that you tried to project here that you're trying to say that the initial suit, the right which was declared, you are, although you are the plaintiff, but your right is restrained to land except 14 lechas. So therefore, your right has been fructified on other part and parcel of land. Please come to that judgment again. The trial court judgment. What does it actually? What is the words used?
One of the earliest,
Yes.
minor appellate judgment.
That finding in your favor is by the appellate court.
Appellate court, my lord.
Awarded 14 lectures.
Finding that starts from paragraph 11.
Page
Look at me, what am I saying?
19,
91.
91.
Present.
Hmm?
Present.
No, the earlier.
Earlier,
Your number.
earlier is page 33.
33. But the judgment is not there. Is judgment available in the trial court record? It is there.
Exhibit 7-2, my lord.
Exhibit 7.
7.
You have a copy? Give it. I'll save some energy. This will help me to save some energy.
Generally, my lord, the finding, the direction is at the last, on the last page.
Story, I'm still not convinced. You see in this para 10 of the para 14 of the judgment, in view of my findings above, the judgment and decree stands modified and the appeal is partly allowed, granting the following reliefs. Number one, right title and interest of the plaintiffs are declared on A scheduled land, leaving 14 lechas on its eastern boundary. And the defendants are also restrained from disturbing the plaintiffs in enjoying the land. Oh, here you are the plaintiff. No, then he's right. Then he's right. His right was not declared.
Really, injunction was granted in our favor against him.
Hmm?
Injunction was granted. Restraining the.
In your favor against him. So therefore it will not be res judicata. These 14 lechas from which he is evicted is rightly pointing out from that decision that it was a incidental, what you call, the incidental finding.
Incidental, during the tenants of the soup mill. They have not raised that question. And in appeal also, they have not raised that question. And in evidence also, he did not say when he was dispossessed. There is their own cross-examination. It's an artificial cause of action. He did not take possession for execution of the sale deed because there was a residential house on their joint property. And prior of this mill or the present suit also for partition. The prayer was for partition of the entire suit land. If prayer for partition, he cannot claim the particular position, particular position. That also, though that is not declared by the. You see the prayer, this prayer in between them. Two prayer may be there. One hand he claim partition, another hand he claim before partition. Before partition, he cannot. That is the necessary. Postportion of the agency.
Is there a sketch map of that land on record? Are you instructed? What is the structure of the land? Because it says 14 lechas on the eastern side is to be given to him.
Yes.
So is it divisible in that manner?
So far, there is one. This case is there. There is some photograph also there. In this case, there is a photograph.
In the miss case.
Because we have constructed the house in our land, madam. So there is that we have constructed. Therefore, there is in this case.
For injunction 1051. মাটির photo নাই স্যার মাটির photo নাই
I think only the suit records are here. Only the suit records are here.
Not recorded, here, second appeal, second appeal.
Only the suit records are here.
Present appeal, second appeal is discussed.
Oh, acha.
The entire photograph of the area my lord is not depicted.
there.
Is not
Only
depicted there.
Only photograph is there.
Can you find out the structure of the land? No.
Lord, this is our house, newly constructed house. There is a vacant land. Probably this is the eastern side. Vacant land.
I can't be sure.
I cannot be.
What is east, what is west, you'll have to find out.
That is there.
Because see, otherwise, Mr. Chaudhary appears to be right. You see, his suit is in a better footing because in the previous suit, your suit, there's a common sale deed. There's only one sale deed in his favor. Out of that, 14 lechas is declared to be his, and no order of partition was made. So even in a sale deed for land which is more than 14 lechas, it was 1 kata 9 lechas. So 14 lechas is his.
Total share of Uma Kolita from whom all the brothers have derived was 2 kotha 3.5 lakhs.
2 kata 3.5 lechas. So he has got
14 lecha each.
no, that sale deed is how much?
Sale deed was for 1 kotha 9.
1 kata 9 lecha.
It's 4 kota something.
Sale deed.
No, my lord.
No,
was-
sale deed is 1 kata 9 lechas.
What Learned Senior Counsel is trying to project is that originally there was a land measuring 4 kotha 7 lechas. There were 2 brothers holding it jointly, Tumbol Kolita and Uma Kolita. Uma Kolita received 2 kotha 3 lechas of 3.5
We are not concerned with that. Right now, we are concerned with that the
Sale
sale
deed
deed
has
is
1
1 kata
kata
9
9
lechas. Out of 1 kata 9 lecha, 14 lecha is declared. It's okay, Mr. We'll come to that niceties later. You see, out of the, let us assume for the time being, even if I am wrong, that sale deed is of 1 kata 9 lechas. Out of 1 kata 9 lecha, 14 is declared to be in favor of the defendant.
No, not 1 kota 9. 1 kota 9 is given to us. 14, beyond that, 14 is given him.
That's what I'm saying.
So not 1 kota from the suit plan, original suit plan. It is
Okay.
1 kota 9 plus 14.
Plus 14 lechas.
Yes.
Okay. So 14 lechas is his. Now that has to be divided in meets and bound to give him
Yeah.
that right.
Yes, ma'am.
So therefore, he has filed a second suit where he says that the 14 acres there should be a partition of that 14 acres of land, and I should be given possession. So he's,
Already in the degree, title degree, 14 laws has given eastern side. Eastern side. So
it's okay.
So my lord, if the general partition is given, then again, my lord, our
No, not general partition, but this 14 acres must be there in the meets and bounds.
kitchen bound in the eastern side. my lord.
Eastern side.
Eastern.
Eastern side. That has been declared.
Rightly, my lord, initially, my lord, for declaration of this and partition. But court, my lord, partition was not given. If partition was given, my lord, it's very his against 14 lesser. We have 1 and 19 lesser. Partition is necessary. But the both the court below, my lord.
Committed a wrong.
Yes, my
They
lord.
committed a mistake.
Yes. That is it. Melody schedule of the subsequent suit, my lord. The plot of land measuring 2 kotha 3.5 lassa out of 7, so the 2 kotha 13 is total land. Out of that, we got, my lord, 1 and 9 lassa, and he 14 lassa. Total, my lord, 2 kotha.
2 kotha,
2 kotha,
3.5 less.
3.5.
3.5 acres.
So 43 lassa, lassa.
Let me reserve it. Go to it. You turn to be a good man now. You see, I have used a different word. I have not said a good lawyer, good man. What does it say? Just tell me, what does it say?
No, regarding, I have not gone through all the metals, but recent.
No, just tell me what is it, because Shruti is something I remember. Just tell me what is it so that I will remember, because
Another government, Laka Gusta 2010, 141, and
yes, yes.
civil court, maybe, end of organization. Section 11, explanation 3 and 4, res judicata. Constructive res judicata, applicability of bar, condition petitioner for according finding of health, are that defendant must establish such plea, and plaintiff must be given notice thereof and opportunity to meet the same. Where High Court did not specify ground of attack, which plaintiff ought to have raised in first suit, but instead he has raised it, second suit, held bar of constructive res judicata not applicable. If not the that attack was not made in the or pleading miller, then it cannot be constructed.
But you made a pleading in your decision. You said so. No. The question is whether res judicata is attracted at all. That is the issue now. For that, I don't think this is an authority.
It's not the authority. Regarding res judicata, it is some deliberation is there.
No, this is on a different footing altogether. Here there were two suits filed for the partition deed, for the partnership firm. One was with the prayer with regard to the this for the dissolution of the partnership, and the second was for rendition of accounts. In the second suit, plea was taken that the suit was barred under Order 2, Rule 2, that it should have been made in the first suit. The trial judge, the High Court, taking up in the original side, dismissed the suit, imposed a cost of 50,000. That was affirmed by the division bench, and therefore it went to the Supreme Court. The Supreme Court says that the basic tenets of civil CPC was not followed by both the courts, because if for deciding Order 2, Rule 2, there should have been a question framed, and then it should have been answered, not without giving an opportunity to the other side to respond to it. And therefore, Order 2, Rule 2 was not accepted. And the trial judge, what he did was he interacted with the husband of the plaintiff, and took a view that oscillating stand was taken, and therefore cost of 50,000 was imposed. Supreme Court says that no, that could not have been done. If cost is required to be imposed, parameters of CPC under 35A has to be followed. Okay. The submissions of Mr. P.S. Degarla at Senior Counsel, assisted by Mr. B.K. Bhagwati, Counsel for the appellants, is concluded, reserving right to reply. The submissions of Mr. N. Chaudhary, Learned Counsel for the respondent, remains respondents remain inconclusive. List again on (5 to 2024). কালকে জমা দিয়ে দিব এটা লিস্ট একটু স্লিপ আউট করব স্লিপ আউট জমা
December 2000 fixed on 52. A photo becomes writing item 5.
item 5 yes
By way of this revision petition working, the order dated 26/9/2023 is under challenge. Here also the plaintiff said the opposite party filed a suit for claiming damages for death of her husband, which was caused due to electrocution. Your lordship will find the plaint at page 19. Page 19 of my petition.
yes
Page 19 is the plaint. They filed a suit for claiming compensation on
yes
account of death of her husband, so and so. That is caused on 3/10/1996 due to electrocution for a negligence act. Now the prayer in the main suit, your lordship will find at page 32. 4 prayers were made.
page 22
32.
32
The suit be registered, defendant be summoned, and C, prayer number C, suit be heard and adjudicated in favor of the plaintiff, passing decree for the amount to the tune of 12 lakh, only with 9% interest from the date of submitting the writ petition. These plaintiffs, they already approached the Honorable High Court by way of a writ petition because there was a issue of limitation. High Court, in disposing of that writ petition, directed that the limitation will be covered because of the judgment of the High Court. So they filed the suit after 5 years. So we are not on the issue of limitation. In the plain, they have prayed for compensation along with 9% interest from the date of filing of the writ petition. Now, after this suit, lordship APDCL, I am appealing for APDCL. APDCL has received the summons and the principal defendant number 8. APDCL filed a written statement, and unfortunately, lordship, after filing a written statement, counsel for APDCL did not appear. So suit proceeded expert.
yes
Thereafter, lordship, the interim judgment, the judgment and decree was passed. The lordship will find it starts from 61. The relevant portion is at 65.
where is the decree
Decree at 61, lordship, the judgment.
61
Judgment and decree, yes. At that time, there was no judicial court. This was passed in 2010 in Kardiangaon. Page 65 is the relevant portion, the issue number 5. Maybe
page
page 65, lordship.
65 yes
The issue number 5. The issue number 5 regarding the entitlement of compensation by the plaintiff cannot be brushed aside as the plaintiff claimed of an amount of rupees 12 lakh only as compensation appears to be reasonable in view of the entire facts of the records, but about the background and history of the plaintiff's family misfortune and their ancillary family future. In fact, the plaintiff is in previous grief of misfortune after the death of her husband. The issue number 5 is determined in affirmative. So compensation of 12 lakh was granted. However, the interest which was paid, it was not granted by way of this decree. And issue number 6 regarding any other relief, it was not granted. Thereafter, lordship, hearing this judgment, judgment and decree, APDCL filed first appeal. In fact, that was dismissed, and second appeal was referred before this court. In second appeal, High Court directed APDCL to file an application since that decree was passed expertly. That was not preferred, and in the meantime, APDCL deposited the decreed amount, lordship. In the meantime, lordship, on page 73, an application under section 47 was filed by the plaintiff side, claiming interest on solution ground, lordship. That petition was numbered as petition number 165.
The second appeal was allowed. What happened thereafter?
Second appeal was not allowed, Lordship. Second appeal was dismissed. We were directed to file an application under order 9, on 13 June 9. That we did not prefer an application, we directly deposited the compensation amount. So we did not challenge the decree. In the meantime, Lordship, at page 73. Decretal amount we already deposited, so there is no issue on that.
This, the order is that appeal is allowed. What is allowed here? Appropriate remedy under
Order,
order 9 rule 13.
yes, that we did not prefer. We directly deposited the amount, so the decree didn't finally.
Okay.
In the meantime, Lordship, on 11/5/2023, the the plaintiff, filed an application under section 47 of CPC, paying for interest on solution ground. Page 73.
Okay. Here interest was granted.
Yes, Lordship. This is my
Number
only case.
47. Okay. Mr.
Harbor.
Arbora, counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 26/9/2023, passed by the learned civil judge within Packet Senior Division, Packet Close, Karbi Anglong, Difu, in connection with petition number 165/2023 under section petition, on an application filed by the respondent under section 47 CPC, claiming interest on solatium in connection with money execution case number 3 of 2011. By the impugn order, the prayer for grant of the prayer of the respondent was allowed by granting the respondent an interest at the rate of 9% per annum from the date of judgment passed in Money Suit 1 of 2002. If you notice, returnable on so and so, give a date after 5 weeks. The petitioner shall take steps within 2 working days for service of notice on the petitioners as to the respondent by registered post with AD. Stop. You also serve by Dasti. You have an office there.
Lordship, yes.
In addition, notice shall also be served on the respondent by way of Dasti by routing the process through the registry of the court, and upon service, and affidavit of service shall be filed prior to the next date of listing. Next, heard the learned counsel for the petitioners on the prayer for interim relief. Having noticed that the trial court had not awarded interest in the judgment and decree dated. Where is that judgment?
Page 61, Lordship.
61.
Yes.
Judgment and decree
Dated 10/9/2010.
dated 10/9,
2010.
2010, passed by the learned Assistant to Deputy Commissioner, Karbi Anglong, Difu, in MS number 1 of 2002. And that in an application under section 47 CPC, a grant of interest, a decrease deemed to have been modified. The court is inclined to stay the enforcement of the impugned order dated 26/9/2023, passed by the learned civil judge with bracket senior division, it was Karbi Anglong Difu, in money execution case number 3 of 2011, in connection with disposal of petition number 165 of 2023. To the next date of listing. Six.
Item 6. Item number 6, 7, 8, 9, 10, and 13 is similar.
Okay.
Order.
Yes.
In order is at 29, annexure 11 lots. We have filed an application under order 6, rule 17 lots before the civil judge Sirang Kajal Lodge. And that petition was rejected by the learned civil judge. The impugned order is at 29 in 2023. On the ground that lordship, we are unable to provide them on which part we are going to amend the petition lordship.
Oh, correct. That is absolutely right.
But in that, in this respect, lordship, CM Vigilance cell has seized all the documents from the BTC authority, lordship. Why, lordship, that yearly 650 crores was sanctioned to that BTC authority, and the tender was for 2,500 crores. 2,500 crores lots. So that is CM Vigilance was there, and one application the central government is also there. That annexure 5 lotship may kindly go through. It is.
No, you see, this is a commercial suit.
No, later on it was shifted to a money suit lotship.
It was converted to money suit.
They have converted into money suit lotship.
So it could not have been. It's a claim for money and interest.
Okay, annexure 5 kindly 86 and 87 page number.
86, 87.
87. This is a scheme lordship, centrally sponsored scheme lordship.
No, you see, Mr. Datta,
Lordship.
you see a vague application for amendment that you want to amend the written statement with what schedule if you don't give. It can't be allowed. Whether your documents are seized by the police or by the vigilance cell or by anybody. But it doesn't give you a right to amend to get an order for amendment of the written statement without giving particulars. That is something I do not know. You'll have to show us from any authority where they have allowed, where any court, any high court or the Supreme Court has allowed amendment of the written statement without giving a particulars.
My main thing is that lordship in that order, it is reflected that whole statement is some.
Just the second way of asking question is, you see, under order 6 rule 17, if an order is passed under order 6 rule 18, what is the time you get for filing of the amended written statement?
90 days.
No. Amendment must be allowed within, there's a time limit given in order 7 rule 18, order 6 rule 18.
kindly adjourn the matter to the Lordship. AG will appear Lordship.
Hmm.
Already Lordship, we have filed 20 numbers of money suit, CRP.
See, 20 or 100 doesn't matter. But the question is that the vague prayer for amendment can't be allowed.
In that respect, Lordship.
Okay, on the prayer made by Mr. Kedatar, counsel for the petition of the matter stands adjourned today. List after ensuing view vacation. Item number 6,
7, 8, 9, 10, and 13.
7, 13. Okay.
Right.
13 is- Item 11. Mr. Bosho, your matter. Yes.
In this case, my lord, I filed a suit before the court of civil case Dhemadi, my lord. My lord, what happened, my lord? To realize 1 crore 90 lakh and all, which was excess excise duty paid to the defendant. Now, my lord, what happened, my lord? After filing the suit, after receiving the notice, they appeared before the trial court. And they on 8/12/2022, my lord,
Yes.
they filed 4 petitions.
Defendants filed 4 petitions. Yes.
My lord, the number 1, which was registered as BJ case number 14 for order 7, rule 10, my lord, for return of the plane.
Yes.
Then, BJ case number 15 and 16, 15 and 16 under section 8(1) and 8(2) of the Arbitration Act, Arbitration and Conciliation Act.
Yes.
And and they also filed another application which is numbered as 195 for deferring the suit. 195 of 2022. my lord,
Yes.
for deferring the suit. But interestingly, on 8/12, while issuing the notice, trial court below, without applying its mind, my lord, allowed all the application. And it's basically a cryptic order. Kindly come to Annexure 6, man.
Annexure?
Annexure 6
Page.
is this, my lord. This. Annexure 6, page 67, my lord.
Page
67.
67.
Today is fixed for
Yes. The person sitting next to you is a lawyer.
my lord, no.
Then you can't be here assisting him.
My lord.
You may sit down in the back or stand up, but you
Yes.
can't be assisting him.
Page 67. my lord.
67, yes.
Today is fixed for submission of WS. I'm sorry, madam. By defendant side, plaintiff side is represented in the petition filed by the learned counsel of the defendant by petition number so order 7 rule 10, 7 rule 10, read with section petition number 197 under section 8(1) of the Arbitration and Conciliation Act, read with section 151 CPC and petition number 198.
This is the order under challenge.
My lord, this order is challenged, and my lord, thereafter, what happened, my lord? They dragged the suit. My lord, orders, petition under order 7 rule 10 for returning the planes by alleging that conservation errors in Meghalaya. So we have to go to Meghalaya. That petition and petition under section 8(1) and 8(2), these are contradictory statements. And they only want to drag the proceeding. And the trial court below, while no separate order was passed deferring the suit for filing of WS and all.
No, this is the only order under challenge.
Thereafter, what happened, my lord?
Hmm.
We have filed one petition under order 8, my lord. And that petition was dismissed by order dated 17/6/23, my lord. Both parties are duly represented at last page, my lord. Last but one. Hundred two, my lord. Also seen petition number, last paragraph, my lord, of page 101. Also seen petition number 141 number censure filed by the plaintiff under order 8 rule 10 CPC related section 151 CPC, where it is stated that the statutory period of limitation for filing the written statement by the defendant side is already over, but till date they have not filed their written statement, and as such the court may pass necessary order in this week. At both the sides on the aforesaid petition, here is the case record. It appears that this court had order
Just a moment.
8/12.
You see, the second order is correctly passed.
Only thing is, my lord, second order was passed on the basis of 8/12 order. 8/12 order, there was no whisper about deferring the suit, man.
No, all these periods were allowed. That means deferring is also allowed.
My lord, all petitions are allowed. And those miscases are
Still pending.
continuing. my
Still
lord,
pending.
pending.
Okay.
A 50 order will create a lot of confusion. My lord, in future, I have to face them.
Okay. Mr. G. Bosho, counsel for the petitioner. Next, by filing this application under Article 227 of the Constitution of India, this 115 and 151, you'll have to either strike it out or we'll have to dismiss your petition. 115. Strike it out, okay. First, at the outset, the learned counsel for the petitioner seeks permission of the court to strike out the provision of section 115 and section 151 CVC from the cause title of this application. Full stop. Prayer is allowed. The said provisions is permitted to be struck off under the signature of the learned counsel. Next para. By this application under Article 227 of the Constitution of India, the petitioner has assailed. The petitioner dash plaintiff has assailed the order dated 8/12/2022 and 17/6/2023 passed by the learned civil judge Dhemaji in TS number 11 of 2022. Stop. By the learned counsel for the petitioner projects that by the order dated 8/12/2022, on the first date of filing of first day of filing, 4 applications filed by the respondent defendant under order 7 rule 10 CPC, comma, under section 8(1) of the Arbitration and Conciliation Act, comma, under section 8 within bracket 2 of the Arbitration and Conciliation Act, comma, and petition for deferment of the suit, comma, were all allowed. First off, it is submitted that despite allowing of these said applications, comma, all the 4 petitions are still being adjudicated. Next, it is also projected that as there is no specific order deferring filing of written statement by the respondent as defendants, the respondent as defendant, comma, the petitioner plaintiff moved an application under order 8 rule 10 CPC, read with order 8 rule 1 CPC as well as section 155 1 CPC for debarring the respondents from filing written statement. Which was rejected by the impugn order dated 17/6/2023. Next, issue notice returnable on so and so. Petitioner shall take steps for service of notice on the respondent by registered post with AD. Post of, in addition, the petitioners are at liberty to process steps through the registry of the court and to serve notice by way of by email, and an affidavit of service shall be filed prior to the next date of listing. Next paragraph. But the learned counsel for the petitioner on the prayer for interim relief. In fact, there is no interim relief to be granted.
If,
You are asking for stay. The suit has already been stayed.
my lord, and the miscase, everything has to be stayed. Otherwise, if another order, I have to come again before. If
No, you see, original,
any-
Mr.
depending on
No,
the
no,
fifth
Mr.
case,
Vaishya,
my lord,
you want this court to take up order 7 rule 10 petition, order 8 rule 2 petition. Should the High Court take it up in rule 27? I can't take it up. So that adjudication has to be there only. The only point is here is involved that the applications were allowed on the first day. Only that much. And if that was allowed, the further adjudication.
my lord, this skeptic order will lead to so many things.
Just tell me what. Tell me one.
That's why I am saying that the suit along with the proceedings may be stayed. Because the next hearing in those cases on 28th.
No, but can I stop that court from hearing?
My lord, in my humble submission, yes, ma'am. It's a power of judicial review, ma'am.
No. Power of judicial review we are not exercising. Article 227 is superintending jurisdiction.
My lord,
Which page was that interim or first order? Where is it? First order, 812 order, which page?
Please, my lord. Page 67.
67.
Page 67.
Having noticed that all the 4 petitions were allowed on the first date of filing by order dated 8/12/2022. And as it is projected that those 4 applications are still being adjudicated even after allowing common, the court is inclined to stay the adjudication of petition number 196 of 2022 under order 7/10 read with section 151 CBC. That is number 1. Huh? Number 2, petition number 197
Number 2 is
of the 22 under section 8 within bracket 1 of the Arbitration and Conciliation Act read with section 151 CBC. Number 3, petition number 198 of 2022 under order 8 rule 2, sorry, section 8 within bracket 2 of the Arbitration and Conciliation Act read with section 151 CPC, as well as petition number 195 of 2022 for deferring the proceedings till further orders of the court. Next, list on so and so.
Biblio.
Huh? 5 weeks, is what?
21.
Item 14, the bail application. Just wait for some time that the APP come. Give a scroll for APP. Item 14.
Item 15. Right, please, Your Honor.
Yes.
My lord, I'd like to take, my lord, 2 weeks' time for filing, my lord, cross objection in this case.
How much time?
2 weeks.
2 weeks. Okay.
My lord, can it be 3 weeks, my lord?
Hmm?
From, my client is from Dumduma, so maybe for 3 weeks.
He wants to come down walking, no?
Lord, she is very correct.
Okay. Both sides are represented. On the prayer made by Mr. Azdata, Senior Counsel, assisted by Ms. S. Mushahari, Counsel for the respondent. List the matter on 1/3.
Yes.
2024, within which time objection to this application may be filed.
Maybe earlier to that.
Huh?
It may be earlier to that.
By that time, I'm saying.
Right.
This is matter appeal.
Matter.
Okay. Has the records come? Checked it? No.
The record hasn't come. Excellent.
This is matrimonial appeal. You will read records, you don't read records.
Records, it's better.
This is only payment of this monthly maintenance only. That is.
Yes, that's the issue only.
NNC and 151 application.
Hmm?
NNC and 151 application.
Enhanced under 151 application.
So like maintenance.
This is
Maintenance pendant.
no. This is this is order of district judge.
Yes.
Huh?
Your lordship will find that page.
No, I'm looking at something separate. There is something different. Just a moment. Hindu marriage is applicable.
Hindu Marriage Act, yes. Essentially, the order is passed under section 25(2) of Hindu Marriage Act.
Its maintenance pendente light was also included.
This is 24, not 25. It should be, it's not a permanent
No.
alimony. It's a temporary,
It's
then
not
it
a
will be
permanent.
24.
Right.
It was passed under 25 since application was 25. So that's why.
No, I'm looking at something else. That's not. Okay. Okay.
The lordship had fixed on 1/3.
First of March.
Month of March. Right.
16.
May we please, your lordship?
Yes.
Lordship, it is a statutory appeal under section 23 of the Railway Claims Tribunal Act 1987.
Your claim was dismissed or?
No, lordship, in this appeal, we are challenging the impugned order dated 29/11.
No, I understand, but why? You are asking for enhancement.
Lordship, in this appeal, we are the consignee of the subject consignment containing 206.
No, please respond to the question. My query is you are asking for enhancement. Why this appeal? For enhancement of compensation. Okay. Your name?
M. Kolita.
Miss M. Kalita, counsel for the appellant, and Miss
Ellen Sharma.
Anand Sharma, and counsel for the respondent. Next, brother. Claiming enhancement of the award. This appeal has been filed under section 23 of the Railway Claims Tribunal Act against the judgment and order, page 1. The appeal is admitted for hearing, call for the records. Issue notice returnable on so and so. Next, as the learned counsel for the respondent has accepted notice, no formal steps is required to be taken. So, however, extra copy of the memo appeal with enclosures be provided to her in course of the day. Next, list on so and so.
21.
21.
Okay.
Item 17. Yes.
I don't, my suit was dismissed on preliminary issue matter.
Pardon me? Suit was dismissed. Okay.
Whether the suit is barred by.
Okay. Issue notice. Heard. Mr. O.P. Bhatti, learned counsel for the appellants. Agree by the dismissal of suit on the ground of limitation. Correct?
Yes.
The present appeal has been filed in the section 96 CPC. Expiration notice returnable on 21/2/2024. So the appellant shall take steps within 2 days, with 2 working days for service of notice on the respondents by respondents and performer respondents by registered post with AD as well as by usual process. Full stop. It is admitted for him, call for the records, steps. The learned counsel for the petitioner is at liberty to collect the postal receipt numbers from the registry and submit postal tract report prior to the next date of listing. List on so and so.
My lord, I have also filed in this case now.
For
Yes, sir. And my play is very limited now.
just a moment.
Yes.
Where is your plaint?
And my lord, your lord is fine. At page 27 of the appeal, 27 to 30. And your lord will find the prayer portion
This is an agreement for 2014.
Yes.
Your suit is filed in 2023, 2021.
2021, and prior to it, my lord, I also filed an application on the arbitration act. Subsequently, when I came to know that his agreement for sale has already been executed with other persons, then I filed the suit. I don't think my lord, this is so I don't think.
No. Just let me understand, first of all, what is it? No, we'll issue a notice on this application because this initial agreement is of 2015.
Yes, my lord. But your
So,
lordship is-
in 2024, we are not disturbing that status quo. No,
status quo, my lord, if they are in position, let them.
No,
review
no,
the
no.
petition, my lord.
no status quo. Injunction application, this IA. Same, heard Mr. Tripathi, counsel for the applicants. Issue notice on this application. And then the other 39 rules 1 and 2, read with section 151 CPC. First of all, the notice is made returnable on 21/2/2024. The applicants shall take steps within 2 working days for service of notice on the respondents by registered post with AD. Same by on a registered post here. Registered post with AD, postally receipt track report. List on so and so. Your section 52 will apply. Eighteen.
In this case, Brandon Xavier. And this.
Just now.
Not have granted by the.
Just now.
Suit for specific purpose of contract lordship. It's a. With regard to the land in question, the page number 9 is the claim. Degree for specific purpose of contract. The fair portion is the page number 18.
Page number 18.
18. A decree for specific purpose of contract may be passed in favor of the plaintiff and against the defendant. After decree, the defendant fails or neglects or refuses to register the sale deed in favor of the plaintiff and deliver vacant possession thereof, the court may please to execute and register the sale deed.
Yes.
This is the two vital prayer. Now, in this particular suit, they have enacted this agreement. This agreement is at page number 27, lordship, is the agreement for sale.
Yes.
I am referring to this particular agreement because of the fact that with regard to this suit, this particular suit land, some previous litigations are pending. It is at page number 29. Page number 29.
29.
Yes. The clause has been inserted at the time of execution of this sale agreement. Paragraph number 6.
Just a
Paragraph 6.
yes.
Paragraph 6. That the seller covenant with the purchaser that 4 cases are pending in the court in connection with the aforesaid land. They are such and such. 44, 54, the complaint case and all these cases. The seller assured that he will withdraw and settle the aforesaid cases along with any other case petition pending in the court relating to the scheduled plot of land within 30 days from the date of execution of this agreement.
So this is,
You are the seller.
I am the seller.
Yes.
This agreement was executed on 26th day of April 2023, and there is a clause that it will be done within a period of 30 days. Now, what has happened, Lordship, with regard to the other suits, the 444/54 2018.
What is the time? Please come again. What is the time?
30 days, Lordship, page number 30. That the seller assured that he will
30 days.
settle all the aforesaid cases along with the other case petition pending in the court relating to the scheduled plot of land within 30 days from the date of execution of this agreement. So the stipulated period is 30 days. So nothing has happened in between that, Lordship, with regard to the previous suit. The settlement came into existence, and pursuant to that settlement, there's a compromise decree between the parties with regard to the previous suit. And I'm having the copy of the particular order. And the possession has already been handed over on 12/10/2023. Settlement between the parties so far as the previous suits are concerned. Then accordingly, the seller hearing or the appellant hearing, he had handed over possession to the person, the plaintiff, with regard to the other suit, or the defendant with regard to the other suit. There's an amicable settlement between the parties.
Yes.
I'm having the copy with regard to that, although I'm not annexed. Now, subsequent to that agreement, the compromise was done on 12/10/2023. Now, the suit was filed in the month of November, subsequent to the compromise. So far as the previous suit is concerned, the subsequent suit has been filed in the month of November. In this particular subsequent suit, the learned trial court, without taking note of what has happened to the present litigation, passed an order granting injunction, the interim injunction. I am basically challenging that particular thing. Now, Lordship, the grounds, I'm not elaborating the entire aspect of the matter. This is a contingent contract, and the contingent contract, Lordship, is very much aware about the fact. The contingent contract is not enforceable because why I'm saying so, because it is dependent on this particular 4 suits which are pending so far as the land is concerned. But since that particular land has been settled between the parties with regard to the previous suit, this particular agreement for sale cannot be enforced. This is a very vital aspect of the matter that has not been taken into consideration by the learned trial court, and the injunction, interim injunction, is in pass. In view of that interim injunction, Lordship, the court which has passed this compromise decree is there. We're not in a position to proceed with the compromise decree. So there is a irreparable loss and injury has caused to the present appellant.
No, it's a status quo with regard to possession, not status quo with regard to
Status quo with regard
suits.
to the possession. That means what? Status quo, now the subsequent stage is there. The compromise decree, in the compromise decree, there's a condition that they will execute the sale deed. They will execute the subsequent, they will take the subsequent steps so far as all the other actions are concerned. Now, we are not in a position to do that because the compromise decree has happened.
No, there are two things. Number one, you don't want to do it. The second thing is that what do you call, there's no endeavor to do it. What of the two is correct?
No, we can't do it at that point of time, Lordship.
You
because-
see, status quo with regard to the suit land
Yes.
is always qua the parties. Does status quo mean that you will, by status quo, can you restrain the, what do you call, deputy commissioner to visit that place? Can you restrain somebody else to go into that land? Can you restrain somebody who is not a party to the proceedings? Can you injunct them?
But that thing has happened.
No, it
That
can't.
thing has happened
It
because,
can't. You show me a proof that the trial court has refused to do it just because there is a status quo order.
no, I'm not on that, Lordship. In view of that agreement between the parties, we have already handed over position to the previously instituted suit, the plaintiff of the previously instituted suit. Now, the subsequent things are to take place because in the agreement, there is an agreement between the parties so far as the previous suit is concerned. We have to execute the sale deed. We have to execute the sale deed. Because of this injunction order, we are not in a position to execute the sale deed. And in previous suits, because the 444 and 54 2018, in those particular suits, there is a status quo order granted previously. In continuation of the status quo order, they have come into an agreement. I have no issue with regard to that. But there is
Where is the
clause.
compromise agreement?
I'm not annexed, but I'm having a.
You file it by way of an affidavit.
They have said that pending. The memo appeal, they've said that that is pending.
Pardon me?
In the memo appeal, they have stated that those suits are pending.
No, I am not concerned with that. The principle of injunction is that it is qua the parties. I don't know if others can be bound by it. Can there be a order? Can there be an order for restraint to the court not to do something? If you have done a compromise, it can be done. It can be done. It is only with regard to the status quo of the parties. It doesn't say you don't proceed with the proceedings.
No, this particular thing has happened prior to institution of the suit.
That we don't know.
Yes, I'll file the additional
You
affidavit
file it.
to bring it on record, but the thing
You-
is that
you
it has
file it.
happened prior to institution of the suit. Now the contingent contract, Lordship, can we see the provision?
No, then you come for rescission of the contract. If that is a plea, in 227, we can't take it up.
But this is not two things.
This is what, this is an appeal, appeal.
Appeal.
So in appeal, you'll have to raise it before the trial court and then come in appeal and then take a ground.
No, I'm challenging this particular interim order, interim injunction order. Lordship.
No.
This is
The time being, you're not,
7/11,
we're not disturbing that.
7/11/2023.
Status quo with regard to its alienation, that you'll have to abide by it.
Alienation,
Good.
Lordship, since it has already been done, because the compromise was executed, the compromise petition was executed prior to institution of the suit. So the learned
Just
trial
tell
court
me
has not gone
something,
into
just
all
tell me
the aspects of the
something.
matter.
Just tell me something.
Yes.
I have no intention to record it in the order, but still I'm asking you, have you refunded the money back
Yes, Lordship, we have already we have refunded the money.
to the,
No, that money we have not refunded.
then you wait for some time. I'll issue a notice and then you formally file that document.
Because that money I have not refunded.
Yes, I suddenly remembered that old proverb. You can't have a cake and eat it too.
No, but the thing is that the documents they have annexed.
No, that's okay. but-
I'm not submitting at this stage because it's not a proper.
It's okay, you
because
file
this-
it, you
because
file
I'll
the
my
document.
this written
You file a
statement and
document, but you
expect
see,
an
if you
FDS
have taken
document.
if you have a specific contract with them to do it within 30 days, to do it and then say that, no, I'm going to sell it to the third party.
No,
You
third
don't
party
get
lawsuit. This is with regard to the previous suit lawsuit. The
Correct.
previous suit, during pendency of the previous suit, this particular agreement was executed. Now, since I am not in the appellant here is not in a position to settle it out in other way around, so we have entered into an agreement with the other party. We have handed over the possession because the possession was previously handed over. The status
No,
quo
it's okay.
was
Once you
there.
have not refunded the money, we are just issuing a notice.
Because the injunction order, the validity of the injunction order based on the irreparable loss and injury. What is that irreparable loss? Because here in this case, because the land in question has already been handed over possession to a third party. These are not in my possession, in the possession of the appellant.
If you have given, then we can't say anything, but so far as the injunction is concerned, we are not interfering for the time being. You file the documents, then we'll see.
And after
When
vacation
do you
also,
want?
pick a date.
When do you want?
Any date after vacation, 17, 18,
After 25.
18th lawsuit or 19th,
19th, okay.
after
I'm
25.
After 25.
after?
25.
It goes to 29th. I'm issuing a notice, meanwhile. Issue notice on this. In this appeal, file under order 43 rule 1 and 2 read with section 151 CBC, which is preferred against the order dated 7/11/2023, passed by the learned civil judge within bracket senior division bracket close number 3 Kamrup Metro Guwahati in MISJ case number 1077 of 2023 in TS 678 of 2023, by which status quo with regard to the suit property was granted. The Mr. Arkemol and counsel for the respondent accepts notice on behalf of the respondent, and therefore no formal steps is required to be taken. So the learned counsel for the petition, for the appellant is granted liberty to bring on record any additional document on which he intends to rely on, which should be filed at least 2 days prior to the next date of listing. List on 29/1/2024.
Regard to the
As a notice including notice on the prayer for interim relief. Okay. Give it discharged. Mr. Kumar shall be heard in the connected appeal. I notice, I is for stay. The stay will be this noticing this. I also, in the appeal, you don't write interim pair, this is separate order. Okay. Item 19,
You can appeal against the judgment dated 7/9/20.
you can deposit 50%.
Yes, sir. We have a IA also,
Okay,
105 of 20.
okay. MSc appeal. Mrs. R.D. Mazumdar, under section 173 of the Motor Vehicles Act. Same issue of 50% deposit within a period of 6 weeks.
Yes. With the registry.
Huh?
Registry.
To the registry.
Hello.
20. Notice. Returnable on 21 to. Notice. 21 to. Item 20. None appears on call for the appellant. Appeal for enhancement of the award. Notice steps within 2 days. Returnable on 21 to. 21 for enhancement.
Yes.
Okay, your name?
HK Gogoi. HK Gogoi.
HK Gogoi, counsel for the appellant. Appeal for enhancement MSCT award. Next steps returnable on 21 to. Steps in 2 working days. 56. Item 56.
Position of civil property by virtue of a sale deed.
Pardon me?
Page 228. First may come to the page 228, which is duly executed. With correspondent number 11 and 12.
Just a moment. I forgot.
Civil for A is the entire land and civil B is my proper land. Yes, I purchased from correspondent number 11 and 12.
Where is the plaint?
It may come to the page. That is the claim filed by the respondent number 123.
Page
234.
plaint.
Filed by the respondent number 123. By narrating they have executed an agreement to sell with the respondent number 4. And subsequently,
Just a moment. Where is a copy of that sale deed?
page 228.
228.
228. That is my sale deed. I purchased from respondent number 11 and 12.
No, what is this sale deed 6172? Which is that? Sale deed number 6172.
That is the agreement to sell executed between respondent number 1 to 3 and 4.
Just 1, 2, 3, and 4.
4.
Where is that?
That is at page 77.
6172 of
That is agreement to
22 dated 13, 11, 22. This is sale deed.
agreement to sell. Executed between 1 to 3. Respondent number 4.
Respondent number 1, 2, and 3.
With respondent number 4.
With respondent number 4. Where is that?
Page 77. That's it.
77. Okay.
Downloaded by having that shoot. That is at page 234. They have learned record get identifying injunction and saying that not to disturb the possession of the respondent number 1 to 3. Whereas schedule B, I already purchased from the title holder. So my respect to
Where is your sale deed?
that is 228. Lordship.
228.
Now by taking the advantage of this.
Just a moment. Just a moment. Yes. Where is the order of injunction?
That is, start from page 264. So,
264.
that is the impugn order. 267, sorry. When landed Banco decided the policy in identity injunction. That not to disturb.
Just a moment. Where was that agreement for sale? Which page?
228.
228. No, that is sale deed. Agreement for sale.
Agreement 77, page
77.
that is executed between 1, 3 and 4.
Just a moment. Mr. Nath, we can only issue a notice. We can't stay the order.
Lordship, my restoration submission is that unless and until.
No, we don't know that. You come to page 80. That's why I wanted those documents. Come to page 80. In page 80, paragraph 1, it says, the vendor do hereby deliver the khas and vacant position of the scheduled property to the purchaser. So here in this agreement, it says that the 1, 2, and 3 has given position to defendant number 4.
But Lordship can come to the page 203.
No, that we don't know. But you see, position is something which is which has to be appreciated. No, no, for that, no, you will get it when it comes. When it is adjudicated, you will get it. No, but two people can't have possession.
But Standard Trial Court, without going through the matter, giving identity injunction, entire property. Whereas I purchased the property, scheduled B property by virtue of it, and came in possession by virtue.
No,
of
you
a-
see, that is the first consideration. You see, this court is also not inclined because of the fact that in the earlier agreement, possession has been handed over.
At the same time, I have to some came in position and with a valid change. That also, that's why I'm.
What are the what is any other admissible proof of your position?
Whereas respondent number 11 and 12 has title. Their name has been shown in Jamabandi copy, official records.
No, you see, in my past life, when I was there, I had experience of all these miscellaneous works I used to do. I had those experience. Now you see, what are the other proof that you are in possession of the land? What is any other proof that you are in possession of the suit land? Except for the sale deed, entry in the sale deed that you are given possession. What are the other proof that?
Your lordship, my there before lordship, at least status quo given to not to disturb my possession. Till the decided on and
No. You see, please satisfy the first point that you are in possession.
I mean, possession, lordship.
What is the other proof?
No, but here is a small house. I have given a photo in my IA. Lordship, it comes. Civil is the entire land.
No, a few days back when traveling in Delhi, I took a photograph of the Rashtrapati Bhavan from the India Gate. Correct. I took a photograph. But does it make it my property? Yes, if I could have taken a photograph in the that Ashoka Hall, sitting in that very coveted chair, then yes, perhaps. No, but where is that photograph? Is it page 85?
Yeah.
It doesn't show anything.
Right, there is small, big, after the big house. There is small, that is my portion of land.
Which one?
It page is 85 first page.
85.
The big, after the big house,
85, there is a house, yes.
next one is small, just right corner.
Right. It's a vacant land right now.
Just corner, behind that big house. First.
Have you moved the trial court for modification of the order? No.
No, next it is 19. That's why I'm paying before lordship. Limited till the any declaration made by the learned trial court. My possession may not be disturbed and no construction may be in the.
No, construction is not coming like that. Unless there is a.
Tell me and make me lordship now. Respondent number 1 to 3. That's why I'm paying till if there's any by sending maybe. Maybe declare null, then it can be. Till then,
protection may be given, Lordship.
Open Barwa.
Lordship, consider that I came in consider with a valid schedule. It's not my fault. They were the title holder, they sold me the land. It was duly executed.
Where is Jamabandi in respect of that land? Where is the Jamabandi of that land?
203 page.
203.
In my appeal, Lordship. Lordship. Respondent number 11 and 12 men have been sold. Iba, Dr. Saikia, and Ronali Sonwal, Borua. 7 and 8 PL number, Lordship.
7 and 8 are the vendors.
From them, I purchased the land.
7 and 8.
7 and 8, Lordship.
I'm not being able to follow you. You have, your sale deed is your sale deed is by Rajiv Dwara.
Then that is the sale deed executed between these 7 and that Iba Dr. Saikia and with Rajiv Dora. They have purchased the land from the Rajiv Dora, who was the son of original Patadar, Lordship. And this
Okay. Your sale deed is by Eva Datta Saikia.
that is 228.
Eva Datta Saikia. Where is the remark of that Eva Datta Saikia?
That is come to the Jamabandi copy, that is page 203, running page.
3 Katha 12 Lachas. Eva Datta Saikia. 6.
Percent 3 Katha 20. out of the total length, that is 1 meter. But schedule A, is the total. My property is.
You better go before the trial court and then adjudicate and come back. You're-
Now.
Make it clear.
Advantage of this order.
No, they're two different vendors. It can't be. It's not easy to accept.
Because by taking the advantage of disorder.
No, you see, the question does not arise. That can't be, it's merely your own imagination that you are being disturbed. The land is separate, the ags and all are separate, vendors are separate.
Come before your lordship.
No. You can't have been threatened, because otherwise you would have been made a party in this suit. In this suit, they have not made you a party. Then,
Until my salary is declared null and void. How can they?
it's not even the same land. It's not even the same land. Why you are, in fact, why you are multiplier proceeding? No, Mr. Nath, I think you are wrong. Your advice to your client is wrong. You are imposing on yourself an injunction. Two vendors are, the two people are different. That's why I now read this Jamabandi. You know what the suit is about? This Bini Guhai. Bini Guhai is one of the legal representative of the Pata holder. Pata holder died and her name was mutated by virtue of probate being granted. Her land holding is different.
But I perceive this Iba Dutta Barua and perceive the land from Rajiv Dwara, who is the son of the original Patadar. That is essentially, Lordship may kindly see the page 218.
218.
It is a sale deed executed between respondent number 5 and 11 and 12. 218, Lordship.
218.
Lordship.
That's why when I wanted to read that, you said no.
By the attorney holder. Rajiv Dwara's attorney holder.
218.
218. Running please.
218.
Is the executor Rajiv Dwara was the son of original Patadar, Parasandra Guru. Subsequently, holder land to his power holder to this respondent number 11 and 12.
Where is the schedule? Three katha, 12 lectures.
Full 2022.
Okay. Where is that Jamabandi?
203.
203.
By virtue of that,
Just a moment.
shown in the Jamabandi copy.
Mr. I am not, sorry, Mr. B. Nath, counsel for the petitioner, sorry, appellant. Next para, agreed by the impugn order, impugn injunction order dated 4/11/2023, passed in Ms. J case number 283 of 2023, arising out of TS number 148 of 2023, audited so passed by the learned civil judge within bracket senior division bracket was Dibrugarh in Ms. J case number so in so by which ad interim temporary injunction was granted. The present appeal has been filed under order under section 104, read with order 43 rule 1 within bracket RCPC. Where is the plaint?
Two 34. Please. Start from two.
You're not a party here in the suit. Are you a party? Your defendant number?
10.
10.
24. It's 237. My name is in.
Next issue notice. Returnable on 21 to 2024. Yeah. Applicant shall take steps within 2 days for 2 working days for service of notice on the respondents by registered post with AD. Postal receipt track number, track report. I heard. This is an application under Mr. Nath, I'll only be issuing a notice in this application. This is under order 39 rule 1 and 2. You see, your argument all throughout while I was listening was that you are saying that the injunction granted in the suit is disturbing you. Now you have come here and you are asking another injunction not to.
Entire land. Whereas landed trial court has to consider my portion of the land, that is 3 kata 12 measure. That was not considered in the impugn order. And
In the impugn order, where is where is that impugn order page? One biga 1 kata 10 lacha, 0 lacha.
67 over entire portion of the land. That you were saying that.
Then you should have asked for stay. We can't grant an injunction. Against an order of injunction, there cannot be another injunction.
In the disposal of this FO or that.
No, that I don't know. If the entire land is 1 biga, can there be another injunction on the three kata land? Can it be granted? Injunction upon injunction?
Not to disturb.
No, we can't travel beyond your prayer.
Not to disturb my position.
You can't,
Not
you,
to
we,
restrict construction
they-
over
they-
that
they-
portion of the
can
land.
there be an injunction against an injunction? Can there be an injunction against injunction? Tell me only one thing. Can it be granted?
Lordship, but at the same time, Lordship may.
No. We can only issue a notice here. We issue notice on this application. Hmm?
I'm
No, I'm asking you a question. You see, as an officer of the record, beyond the brief, you'll have to give a reply. Can against an order of injunction, there be another order of injunction? If it can't be granted, it can't be granted. You can stay the operation of that in your insofar as your appeal is concerned, but that is not the prayer made.
There is. No person.
No, we can't do that. We can't travel beyond your prayer. Notice of the application steps and so and so. This one says. Any. We can't help it, Mr. Nath. That's why I had to stop. We'll just say here, the pendency of this this application as well as the connected appeal shall not be a bar for the petitioner to move the trial court with an appropriate application and to participate in the injunction proceedings. You said it's not a bar. You can go there. You can ask for modification under order 39 rule 4. That can be done.
Taking the advantage of this appeal order. Now, my position is sitting.
We come with an application, we can't, but the injunction upon injunction we can't do. It is only when we were small kids, we used to play cards. And there were 52 cards. Two of us will divide, half and half. And then we'll keep on piling up cards. And when you put on 2, I also put on 2, then I win. I take it back. So that was something we did when we were children. But to give an order of injunction against an order of injunction, that is something you'll have to convince me. Subject to convincing, we will do it. You take up item 14, bail application. You're there. This is AB 420.
Your Lordship was pleased to reject by prayer not after.
Page 21.
But what
Well-
prompted the petitioner to approach again before your Lordship? The petitioner is relying upon one judgment of the Supreme Court, my lord. The petitioner is relying, my lord, upon the judgment of one of the Honorable Supreme Court.
Yes, where is that?
Because in this case, my lord, the allegation is that I have misappropriated the money, scholarship money of some of the students, my lord. But subsequent to the dismissal of the petitioner's prayer, my lord, the money was paid to the litigation. And that the informant has also admitted that, my lord, and to that effect, my lord, he has also shown an affidavit. So in this case, my lord, the Honorable Supreme Court granted the concession of, my lord, anticipated bail, considering the fact that the accused person, my lord, made the payment. At this stage, my lord, my humble and limited prayer will be, my lord, city may be called for to, my lord, know about the latest status of the investigation and to justify as to whether my
Custodial interrogation.
Inform us on the next date about this. You see, this order would not help you. This Bimla Tiwari is a case where there was an order of demand dowry. There was an allegation that 6 lakhs were demanded. And then because of subsequent development, this money of 6 lakh rupees was returned. So therefore 498A and all, court said that, okay, please grant bail because he has returned the money.
Of course, yeah, exactly. Your lordship.
Hmm.
Even then,
Hmm?
No new ground.
the grand.
No, there's a new ground. He's saying that the entire money has been paid up. So if your investigation shows that he has been paid up, then he is entitled to pre-arrest bail. Heard Mr. A. Ali, counsel for the petitioner. As well as Mr. K.K. Das, learned APP for the state. Next, this is the second bill, pre-arrest bail application by the petitioner under Section 438 CRPC against, apprehending, arresting connection with Boko PS case number so and so, page 1. Next para, the learned counsel for the petitioner has submitted that during the intervening period, the petitioner has returned the money due to the money allegedly due to the concerned student. Full stop. In that view of the matter, the learned AVP shall obtain updated case diary and or specific instructions as to whether money of the informants have been paid by the petitioner. Full stop. The learned AVP is permitted to send a downloaded copy of this order to the IO or to the concerned police station to obtain instructions. List on
24.
24. Okay, 24/1/2024.
Item 23.
Have to be adjourned for the day, Lord. The conducting counsel, Mr. and the Dattai left due to some urgency.
Okay, you have the case diary? Okay. Yes. I'm adjourning the matter, but take the date after some time because next week there is some what you call. I may not be available, but I'm not sure till now. So let me check my diary and he'll check it out. Just correct the information after some time because right now I don't have the information. I'll have to check my diary and then tell. After that, eyes only, then we'll correct the information. So please check it up after some time. There may be some disruption of what you call my court. Yes, this is item 24.
Concurrent findings, no?
Today we'll have to adjourn it. I may not have time to start. Huh? Record has come.
জনাই দিম ডেটটো মই ফোন কৰি জনাই দিম।
Mr. Sharma, when do you want?
After vacation, I need it.
You have a calendar, just tell us the date, because since we want to accommodate you, we are seeking your convenient date.
January.
Yes, of course. The positive time matter could not be taken up today. As agreed to by both sides, list on 29/1/2024. Yes.
I'm appearing in item number 53, my lord. There was
Yes.
an interim order which is operative till today, my lord.
53, okay. All interim orders will be extended. 53, your name is not there. Oh, okay. 53 interim order extended. Any other case where interim orders to be extended? You make a mention, because I'm not passing any orders due to some technical problem I am facing. 41, 42, okay. We are not saying anything, we are just rolling it over. You make a mention. On the next opening day, please make a mention below.
But item number 52 also there is interim order till today.
52, okay. Interim order extended, what says represented? Yes.
I am not praying for correction of this order, my lord, only one order, my lord. Praying for correction of this order, my lord.
39.
39, my lord.
What is the mistake?
My lord, page 8, my lord, there are 3, my lord. This is likely created confusion, and the same is required to be corrected, the inserting the word disposing in place of the word of disposing, my lord. That is all. my lord.
Just pass me on. Write it down and pass it on. Write in a piece of paper and pass it on. Okay. 39, okay. I got it. Which page?
8, my lord.
Page?
8. My, I have written, my lord.
Who is for the other side? This is item number 39.
I am, my lord.
Where was this order passed? In the red petition?
Writ petition, my lord, 8416-2022, my lord. Actually, this I am listed several times, my lord, but time is not covered.
No, this is to come with the names of the land council appearing for the others. 89.
And the next, my lord. On order, my lord, there is other set, broken name.
Which paragraph of the order?
My lord, page 10, my lord, para 7, my lord.
Page 10.
my lord. Page 10, Tera 7, last line, my lord.
No, page 10 is affidavit of your IA.
I have the next order, my lord, that is the last page, my lord. Annexure 1, my lord.
Yes, which paragraph?
Paragraph 7, my lord.
7.
Fourth line, my lord.
Oh no, that's why you see the difficulty. This order was passed in writ petition, correct? So this IA should have been filed in the writ petition.
Only for this correcting this order, my lord.
No, no, no. This was tagged with contempt petition. Because in your what do you call this page in contempt petition, names of the counsel for the respondents are not listed. In the writ petition, only the respondents have appeared. In contempt petition, they will not appear. They will appear only on receipt or notice by through. Maybe they can engage another counsel. Order corrections must be made in presence of the counsel. Correct. So this is wrongly done. This is annexed to this IA is with contempt. In contempt, there is no order. The order is in writ petition. So this IA should have been in the writ petition. Correct. We'll ask the registrar to correct it. Then only it can come with the names of the counsel for the respondents. Orders must be passed in the presence of counsel.
Serve this copy, my lord, only all this respondent, my lord, that is made the party, my lord. Copy served, my lord. Yes.
You understand what I am trying to say? IA is tagged with contempt. In contempt, there's no mistake in the order. The mistake in the order is in writ petition. So IA should have been tagged with the writ petition, not with contempt. Correct. So here you see in the cause title, in the cause list, item 39, IA is so and so in contempt.
My lord, my lord.
Correct. It should have been with writ petition. Then only the writ petition always will appear. Okay. Heard Miss L. Wazida, counsel for the petitioner, sorry, the applicant. So it appears that this interlocutory application is wrongly tagged with con case C 295 of 2023. For the since this interlocutory application is for correction of order passed in WPC 8416 of 2022, let this interlocutory application be tagged with WPC 8416 of 2022. To stop, the registry shall also reflect the name of learned counsel for the learned counsel appearing for the respondents as counsel for the opposite parties when listing this matter. Next.
Any date may be fixed, my lord.
Pardon me?
Any date may be fixed, my lord.
I'm not fixing a date. I don't think court master will give it after some time. The next week there may be some what do you call uncertainty. We'll give a date after some time. Please collect it after some time. Yes.
Item number 34, Lord.
Yes.
The interim order in the IA, Lord.
There is an interim order in IA. Okay, 34. IA. Okay.
Item 57. On the last day also, the matter did not raise. Date may be fixed.
I'm not fixing a date. This will all be left over. If you want, you can make a mention. Correct? In item 57, I can't pass an order. And in earlier 20 cases, I am not passing an order. Correct? Make a mention. It leads to some administrative difficulties.
Item 25. Item 25. Date be fixed.
I'm not fixing a date. It will all be left over. So wish you all a very happy view for all of you.
No.
টাইমটো মানে যেতিয়া এভেইলেবল হয় আৰু তোমাদের আছে
ইয়াতে আপোনাৰ মোবাইল নম্বৰটো লিখি যাওক এই ৰেজিষ্টাৰ লগত কথা পাতিব গৈছে আমাৰ ছেকেণ্ড কোৰ্ট মাষ্টাৰজন তাৰৰ কেতিয়া বেঞ্চ পৰে সেইটো তেওঁক সুধিব গৈছে তাৰ ওচৰতে ডেটটো দিম মই ফোন কৰি পেলাই জনাই দিম হা আপোনাৰো যদি ডেটটো ইয়াতে দি দিয়ক মোবাইল নম্বৰটো দি দিয়ক মই ফোন কৰি দিম ডেটটো পাই যাব হা
ডেটটো আমাকে ফিক্স করে দিছেন কি
ঠিক আছে থ্যাংক ইউ 7 আওয়ার লেট ওভার হবে নহয় মানে যিবিলাকৰ ইণ্টাৰিম নাথাকে সেইবিলাকৰ ডেট ইণ্টাৰিম আছে নে হ'ব হ'ব দিয়ক হয়
ক'ত আছা?
ৰাভা হেল্ল' ঠিক আছে
বোলো বিহুৰ পইচা জনাব